On February 18, 2026, in the 36th District Court of Detroit, Michigan, tenant Derek Lewis faced an eviction hearing brought by landlord Good Deal Properties. The case, originally scheduled for resolution through a $4,000 settlement agreement, collapsed into dispute when the landlord allegedly accepted and then blocked the electronic payment. What began as a straightforward pay-to-quit arrangement devolved into conflicting testimony about verbal agreements, attorney involvement, and serious allegations of uninhabitable living conditions, including a caved-in roof, raccoon infestations, and non-functional plumbing.
I put you on mute, ma'am. Good Deal Properties versus Derek Lewis, 25-08209. You're on that side, they're on that side. Council appearance.
Adam Christensen on behalf of.
Okay, Mr. Lewis, I think this was a second date reset because I think you represented to the court last time that you had a agreement with the plaintiff that if you pay or if he accepts $4,000, that the case would be dismissed. You were supposed to be providing evidence of that agreement and then evidence that you paid $4,000. You can show it to them.
This just says it's $4,000 was paid to the civil division, but.
Well, I got an email yesterday about an escrow. I didn't know why I was getting an email about an escrow. What is the email or the text message that he said if you paid $4,000 in escrow?
Oh, no, it didn't say in escrow, but
on February 24th.
I don't have an email. What happened was, it told me that the payment had been blocked on my end. I also brought evidence to show
That the payment was blocked, but you do have a message that is supposed to demonstrate that there was an agreement.
Yes.
Where's the text message? And if you think I can read a text message off of a Zoom, off of a TV, I can.
Oh, I'm sorry. I mean,
do you have plenty of time to have them send it to you?
Oh, I had the text message, but you said a screenshot wouldn't suffice, so she needed to come on Zoom, but I didn't understand.
That she received the text message?
Yes.
You have a screenshot?
Yes.
I mean, is that what you showed me last time?
Mm-hmm.
He showed you the screenshot?
I'd like to review it.
Yeah, you can sit. I don't remember. You can show the plaintiff's attorney. I think the issue was you said that she made the payment or something to that.
Yeah, so she sent the message that got accepted.
She sent the communication and the payment, or you sent the payment?
So she sent the communication and the original payment. So when I called up to the courts and told them that I got a
The tenant, Derek Lewis, attempted to resolve his eviction through a settlement payment that the landlord allegedly accepted via electronic transfer, only for the payment to be subsequently blocked or reversed. The judge is now attempting to determine whether a binding agreement existed and whether the payment was properly tendered and accepted. Under Michigan's Summary Proceedings Act, specifically MCL 600.5744, landlords must provide tenants with proper notice and opportunity to cure rent arrears before obtaining an eviction judgment. The Act requires strict compliance with statutory procedures, and any settlement agreement that resolves a pending eviction must be clear, unambiguous, and supported by consideration. Additionally, Michigan contract law, as articulated in the Uniform Commercial Code, Article 4A, MCL 4404101 et seq., governs electronic fund transfers and defines when payment is accepted versus when it remains conditional. The UCC distinguishes between a receiving bank's acceptance of payment instructions and the final settlement of funds, which becomes critical when parties dispute whether payment was actually received. Here, Lewis transmitted $4,000 electronically with an explicit condition. If you do not intend to cancel the hearing, please do not accept the payment. Under UCC 4A209, a payment order is accepted when the receiving bank executes the payment or notifies the sender of acceptance. The landlord's apparent acceptance, followed by the payment being blocked, creates a factual dispute about whether there was mutual assent to a settlement. If the landlord's banking institution blocked the transfer due to identity verification issues, as Lewis's witness later suggests, this may constitute a failure of consideration that prevents contract formation. Conversely, if the landlord affirmatively stopped payment after initial acceptance, this could support Lewis's claim of bad faith negotiation, potentially affecting the equitable considerations under MCL 600.5744. This dispute illustrates how informal settlement negotiations in eviction proceedings can create more litigation than they resolve. Tenants facing eviction often lack legal representation during critical settlement discussions, leaving them vulnerable to agreements that landlords later disavow. The distinction between acceptance of payment instructions and actual receipt of cleared funds determines whether Lewis's eviction can proceed or must be dismissed, a determination that hinges on technical banking law most self-represented litigants do not understand.
That's the payment is blocked, and I asked him, what should I do?
Got it,
Got a
okay.
supervisor and said, this
You
is
can
what
show him what the communication.
You can send it to me again. Going through all of these messages.
Can you get this? Okay, this is a text message, it looks like here. This was sent on February 17th, a communication between the two. This is per our verbal agreement. I am sending payment based on your agreement to cancel the pay to quit hearing scheduled for February 18th with Judge Simmons. If you do not intend to cancel the hearing, please do not accept the payment. And so he did not accept the payment, correct?
No, that was the other part of the screenshot that
What
said
other
the
part?
landlord accepted. Oh, I'm sorry. We looked at it last year. I can pull
But
it
you
up
just
for
told me it was blocked.
Yeah, so he accepted, and as it was going through, because even in court, he said, well, I haven't gotten it. So I called the courts to ask them, how can I make sure that he gets this payment, because that's rather pertinent for getting the judgment. But it came back with a message stating that the payment was blocked. I got that as well.
You can show me what you have.
Here's the ledger from when I sent the payment, stating that money was in the account.
So you send it through some mechanism, you have to show him. You send it through some mechanism, they have to accept it.
Correct.
And then,
So they chose to accept it. I'm sorry.
but at the time of the last court date, he had not accepted it.
No, he had accepted it. So that's why you said, as long as you show me the text message when you come back in, it's dismissed because you've accepted payment. per
He
the
told you that?
contract. No, that was what you said. The last
No,
time.
well, it can't be accepted and then rejected. I don't think,
The judge confronts a fundamental contradiction. Lewis claims the landlord accepted the payment, yet the payment was somehow blocked or reversed. The text message reveals Lewis attempted to create a conditional contract, payment in exchange for dismissal, but the condition's satisfaction remains disputed. Michigan follows the mailbox rule for contract formation, but electronic payments trigger UCC Article 4A's specialized provisions. Under MCL 440.4A-2091, acceptance of a payment order occurs when the receiving bank executes the order or sends notice of acceptance. However, UCC 4A-402B allows a receiving bank to reject a payment order if the sender's account lacks sufficient funds or if other conditions are not met. Critically, the 2012 Michigan Court of Appeals decision in Talbot Partnership v. Krisman emphasized that settlement agreements in pending litigation require meeting of the minds on all material terms. Where parties dispute whether a settlement encompasses all claims, including counterclaims as Lewis alleges, courts must determine whether the agreement was sufficiently definite to be enforceable under MCL 566.132, Michigan's statute of frauds for contracts that cannot be performed within 1 year. Lewis's text message attempted to create a unilateral contract offer. By accepting payment, the landlord would implicitly agree to dismiss the eviction. However, the landlord's attorney now contends the $4,000 was merely partial payment toward a larger $14,300 arrears with continued tenancy and payment plan, not dismissal, as the consideration. This creates a classic battle of the forms scenario where each party understood the agreement differently. Under Krisman, if the landlord believed he was accepting payment subject to additional terms, the payment plan, 90-day extension, while Lewis believed he was purchasing complete dismissal, no contract was formed due to lack of mutual assent. The judge's skepticism about accepting and then rejecting payment reflects judicial reluctance to permit parties to exploit technical banking delays to escape settlement obligations. Self-represented tenants frequently attempt to negotiate settlements without understanding that their informal communications may create binding obligations or fail to create them when most needed. Lewis's carefully crafted conditional message shows some sophistication, but the lack of written confirmation from the landlord's side leaves him vulnerable to the attorney's after-the-fact characterization of the agreement. This dynamic explains why Michigan's state bar and legal aid organizations strongly advise tenants to obtain written settlement agreements, or better, representation before negotiating with landlord attorneys who draft enforceable contracts professionally.
how can you accept the payment and then reject it later?
I'm not sure if it was because of the banking institution or if he called to stop payment on the banking institution. I just know that they said landlord has accepted your payment. So when I called the court to
That's
tell
what I'm
them,
looking for. I'm not looking for something, okay, is that what it says, payments canceled?
No, so payment canceled, I was just showing the difference. So the payment canceled was when the payment actually got canceled because it timed out, because he didn't accept it in time. So that's just showing the difference
So
between
he
someone
didn't accept
blocking it and somebody's canceling.
So he didn't accept the payment. You have a witness raising her hand. Did she want to say something? Ma'am, what's your name?
Shy
For the
test.
record? Let me have you raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, why are you raising your hand?
So the initial payment, I just sent another screenshot of that, said that he accepted it on the 17th. It said that the payment was canceled because my identity wasn't verified based, I guess, on the amount that I initially tried to send of the $4,000. And I have documentation of that as well.
She said she just sent you another screenshot. And the past due alleged amount is how much?
14,300.
Okay, so this agreement was not just for you to pay 4,000 and it resolved the balance, just to cancel the eviction, is what you're saying?
No, so the agreement was so that we didn't have to come back to court, because I informed them that I would be countersuing as well. So that number wasn't going to be that number. So I asked them for a settlement number in order to pay. And
where's the
have it resolved.
communication for that?
That was the verbal agreement that I told you about the last hearing.
So you were gonna file a countersuit for what?
Unlawful lockout during business hours because it came with a padlock on
You got
the.
locked out of the property
Right.
during the eviction?
No, before the eviction, it was just basically send money on, and I'll give you the code to the lock, or
Oh, okay. What else?
damage to the property due to the maintenance of the building. The roof is caving in and it has a hole in the ceiling, so my property is being damaged.
The roof is caving in. There's a hole in the roof
Yeah, there's an actual.
presently?
Yes, yeah. It's snow comes in. Varmints from raccoons that got into the hole of the roof because he used a hubcap to cover the chimney block. So raccoons got in there and knocked things off some shelves and also caused more damage. No plumbing, so it floods. Anytime that the water is on, I have to take a bucket in order to get water in order to flush the toilet.
Okay, so you were gonna do a countersuit is what you told them, and then that's why you say based on our verbal agreement. Okay. Did you want to respond?
But as far as I know, the agreement was between the parties was that he would accept $4,000. The $10,300 that was remaining would be paid over time. The defendant would be allowed to stay another 3 months.
You're talking about what you try to negotiate though.
Well,
What about this agreement that he didn't involve you in?
I guess Mr. Markovic would have to testify to that, Your Honor, because
Raise your right hand.
I know what he communicated to me.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. He told you he was countersuing, correct?
He said that while we're up here. On
No,
18.
before we ever came to court. You had a phone conversation with him?
Never said anything.
You never
about
had a phone conversation with him?
I have had a phone
What
conversation with him.
what day was that? It was
The
the,
17th.
you had a conversation with him on the 17th, the day before
I've had
court?
multiple conversations. You have to be specific.
On the 17th. You had a conversation with him, which is the day before.
I don't remember if I had a conversation on the 17th. I can't
Okay.
remember which
Do you
day
remember
it was.
having a conversation prior to court about how you can resolve this?
Yes,
Okay. And did he offer $4,000?
I offered. That
You offered $4,000?
I offered if he gave me $4,000, the remaining 10,300 you can make payments on the next 2 years. And then after that, I'll give him 90 days and still had to pay the existing $1,700 a month until March or May 30th to move out. So he had plenty of time to move out because he's worried about no place to go. And I give him cheap rent for what he gets.
Okay. I don't believe you told him. I believe that the attorney came in and advised you because you hired an attorney, but then you tried to negotiate without the attorney. The attorney, I believe the attorney is the one who came in and intercepted this because I see a text message from this man sent to you, or it could have been from her, but nonetheless, per our verbal agreement, I don't see anything in response to you saying that wasn't our agreement.
I had Ed send over the agreement on the 17th.
You sent over what agreement?
What I just stated to you.
How did you send it?
Well, I asked Ed to send him an email.
He didn't talk to Ed.
Yes, he did.
You talked to the attorney on 17th?
Yep, so when-
Before or after? you talked?
after I talked to him, so I talked to Mr. Malkovich and I said, I sent the money. Did you receive the money? He says, yes, I got that. I accepted the money, or I accepted to receive the money. Obviously, it hadn't hit his account. His
Okay.
processing days. So I said, well, can you give me the paper that states that we're not going to court so I can file on my behalf as well? I just leave it to their responsibility. He says, yes, here's my attorney's number. So I called the attorney and me and him talked and he says, oh, you guys came up with an agreement? I said, yes. He said, what did you guys come up with? I said, I give him $4,000 and $1,700 a month I have to pay rent on time. Okay, well, that means I'm gonna send you a document for you to sign.
So $4,000 and then $1,700 a month, was that already your rent?
So the rent was $1,200
Okay.
and then it went up to $1,700 once he
Okay,
got
so
it.
your agreement was you're gonna pay $4,000 and agree to pay $1,700 a month, and then he would dismiss the eviction.
Correct,
So you were waiting for paperwork from the attorney,
correct.
and then what happened?
So then, not even 2 minutes later, Andy calls again and states, oh, my attorney brought it to my attention. We never discussed the rearage. I said, what are you talking about? That's what the settlement is for. Why would we not discuss the rearage? We didn't discuss the rearage because it was a settlement. Oh, no. That he brought it to my attention. I wouldn't accept that for back rent, blah, 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 blah. But now you already have the money and you have an agreement. So now you're trying to figure out a way.
Yeah, and then his attorney told him to reject the payment. I believe his story, I don't believe that one.
I didn't.
No, I believe that he had an agreement with Tim, they didn't involve you. Which you have no business doing when you have an attorney, but you did it. And then you can put your hand down. And then after he's waiting for paperwork that memorializes this agreement he just entered into, you spoke to him, and that's why he was candid and said, oh, my attorney brought it to my attention that I didn't address X, Y, and Z. I believe that's what happened. I believe that he entered into agreement and didn't address all the things that he thought he was addressing. I believe that.
Yeah, it was an incomplete,
Yeah.
an incomplete agreement. and
No,
it-
it wasn't an incomplete agreement. An agreement is agreement. They had an agreement. He didn't address all the things that he would have liked to have addressed because he wasn't being counseled. But he took that upon himself. When he spoke to this guy to have an agreement, he just said, talk to my attorney.
I don't disagree with that, Your Honor, but it's that 10,300 still has to be addressed somewhere.
Not if you have an agreement. You can have an agreement that I'm not gonna address. We have it all the time in here. You can have an agreement that I'm not gonna address it. If he said the agreement is I'm gonna pay $4,000 and he makes a reasonable assertion as to why it was that way, because I'm countersuing for unlawful eviction. He said he was locked out of the property. He said that there was damage to the property, that he has no plumbing, that there's a hole in the roof, that raccoons have gotten there. We can proceed with the hearing and see if there's a rearage. We can do that. He can bring evidence of these issues. He can bring evidence of whether or not he was locked out of his property unlawful, which would wash this eviction. He can bring evidence that he's been dealing with habitability issues if he wants to proceed that way. Or he can do countersuit if that's what he wanted to do. I don't think he's filed a countersuit, but he can use that to abate it. If that's what he believes he has an argument for. But he's saying that he's told your client this, and that was the reason why your client was willing to make the agreement that they made to wash the countersuit.
First time hearing that, you spoke with him for a good 20 minutes.
Lewis's witness, Chi Tesla, provides critical testimony that the payment was blocked not by the landlord, but by the banking institution due to identity verification failure on a large transfer. This transforms the narrative from landlord bad faith to potential technical banking obstacle, while Lewis simultaneously reveals his settlement understanding included waiver of counterclaims for habitability violations. Under Michigan Court Rule 2507, settlement agreements in civil cases must be fair, adequate, and reasonable when they release unknown claims, and courts scrutinize whether parties knowingly waived rights they understood they possessed. The Michigan Supreme Court's 1999 decision in Madden v. Borg-Warner Automotive, Inc. established that general releases are construed against the drafter here, the landlord's attorney if he prepared documentation when ambiguity exists about scope. More critically, Lewis's allegations trigger the implied warranty of habitability under MCL 554.139, which Michigan recognized in Javins v. First National Realty Corp. 1970, as a fundamental protection, making uninhabitable premises a defense to eviction for non-payment. Under Javins and subsequent Michigan cases, tenants may withhold rent or obtain damages when landlords fail to maintain premises fit for human habitation, with serious structural defects like caved roofs and lack of plumbing constituting classic violations. If Lewis's counterclaims for uninhabitable conditions have merit, his $4,000 payment may represent not merely rent settlement but consideration for releasing valuable claims under MCL 554.139. The landlord's attorney's post-acceptance attempt to recharacterize the agreement, allegedly stating, "We never discussed the rearage," suggests recognition that a global settlement including habitability claims would be substantially more valuable than mere eviction dismissal. Under Madden, any ambiguity about whether the settlement released these claims must be construed against the landlord. Meanwhile, the banking verification failure introduces UCC 4A22, which permits receiving banks to reject payment orders exceeding verification thresholds, potentially excusing non-performance if Lewis cannot demonstrate the landlord affirmatively prevented payment completion. This testimony exposes how landlords and tenants negotiate at massive information asymmetries. Lewis appears to have understood he was purchasing peace from all landlord-tenant disputes. The landlord's attorney, Jetru after the fact, recognized this would extinguish claims worth potentially more than the arrears. The habitability allegations, if proven, transform this from a simple non-payment case into one where the landlord may owe the tenant damages, explaining the attorney's urgency to correct an agreement his client apparently made without counsel. For educational viewers, this demonstrates why Michigan's Right to Counsel pilot program in Detroit eviction courts provides tenants' attorneys who can value counterclaims and prevent precisely this type of exploitative renegotiation.
30 minutes.
Yep.
I didn't hear anything about any counterclaims.
You have evidence of the things for your countersuit?
Yeah, I do. I have the unlawful lockout. I have a picture with the lock and his name. Call me now.
When did he lock you out of the property?
What was the date of that? I have the records of that.
You have evidence
August 5th, I believe. It was.
August 5th?
Yes, it was
Yeah.
August 5th. I have the text where he sends me the code to unlock the door after he was sent.
So it was a shakedown. I'm gonna lock you out the property until you give me money. When we have a lawful eviction process, and your client can't do that. That's the first you're hearing of this, counsel?
I haven't heard any
Okay.
of these counterclaims, Your Honor, so.
Okay, well, at this point, it's a defense because he hasn't filed a counterclaim. And you all are disputing this agreement. So we're gonna see if it's.
The tenant presents evidence of an alleged unlawful lockout in August 2026, where the landlord allegedly locked him out and demanded money for re-entry. The judge notes this could constitute a defense to eviction, but emphasizes no formal counterclaim has been filed. Under Michigan compiled laws section 600.5744, a landlord who engages in self-help eviction, including locking out a tenant without court order, may be liable for damages and attorney fees. The statute explicitly prohibits landlords from forcibly removing tenants or excluding them from possession without judicial process. Additionally, Michigan Court Rule 2.1112 requires counterclaims to be filed with responsive pleadings. Defenses raised without proper pleading may limit the remedies available to tenants. The tenant's testimony describes classic self-help eviction, being locked out and required to pay for re-entry. This could trigger damages under MCL 600.5744, which allows tenants to recover actual damages, statutory damages up to 3 times monthly rent, and attorney fees. However, by not filing a formal counterclaim, the tenant risks having these issues treated merely as defenses to the eviction rather than affirmative claims for monetary recovery, substantially limiting his potential remedies. This illustrates the critical difference between raising defenses and filing counterclaims in eviction proceedings. Tenants with meritorious claims against landlords can forfeit significant remedies through procedural missteps, underscoring why legal representation matters in housing court.
Debated. What is the evidence that you have for damage to the property and the roof issues? I'm gonna go off the record. You go get your evidence together because you're taking up entirely too much time. You should have had this together because I reset this. I need to see pictures or anything that you have that you believe supports your claim that you've been dealing with issues of conditions of the property. That also gives you all an opportunity to go ahead and see if you can negotiate this one last time, because if I have to make a ruling Somebody's leaving here upset. Ma'am, I'm gonna put you on mute while they try to resolve this, okay? Okay, I have Capital Manor. Wait a minute, let's see. What's the matter, Anna Martine?
Okay.
Isn't she here? Are you all ready? Okay, we're back on the record. Your evidence, or do you all have a resolution? No resolution, correct?
No, we
Okay.
can come up to it.
Okay, give me just a moment. You showed them the alleged evidence?
I mean, kind of turned into like email
Okay.
communication and everything, so. I don't think he needed to see the lockout.
You should have to show him.
Oh.
No, or his attorney, but,
That's all.
okay. What about the damage property? You have evidence of that?
It's the ceiling. It's the garage doors. Routine maintenance, I understand, changing the light. It's not my responsibility.
Okay, what am I looking at, sir?
So those are the tiles that are.
After an unsuccessful settlement conference, the court returns to the record to examine photographic evidence of property conditions. The tenant shows ceiling tiles damaged by animals entering through a hole in the roof, while the landlord characterizes repairs as tenant responsibility. Under Michigan compiled laws, Section 554.139, landlords of commercial properties have different obligations than residential landlords, but still must maintain premises in reasonable repair according to the lease terms and common law. In Javins v. First National Realty Corp., 428 F.2D 1071, DC Suro 1970, the court established that lease agreements carry an implied warranty of habitability for residential tenants, though commercial tenants generally bargain for repair obligations contractually. However, structural repairs, particularly those affecting the building envelope, typically remain landlord responsibility unless expressly shifted by lease. The hole in the roof allowing animal entry represents a structural defect that likely falls outside routine tenant obligations, regardless of lease terms. The landlord's assertion that ceiling tile replacement is routine maintenance mischaracterizes the underlying issue, a roof penetration causing ongoing damage. If the lease does not explicitly assign structural repairs to the tenant, Michigan courts would likely find this a landlord obligation under both common law and any implied covenant of quiet enjoyment. Commercial tenants often assume greater repair responsibilities than residential tenants, but landlords cannot contract away liability for structural defects through generic lease language. This evidentiary exchange tests whether the party's lease actually allocated roof repairs to the tenant, a determination that could shift thousands of dollars in liability.
Knocked down because of animals and things getting into the hole that's in the roof.
You have a picture of this hole? And what was you saying about the bathroom?
So the bathroom, I have a picture in there of that as well. That's the plumbing. It's a hole in the plumbing, so we have to turn off the main water valve in order to not have the place flood. If it's flooded plenty of times because of the type of plumbing.
What do you mean the type of plumbing?
I was told by someone that
Okay,
familiar
Don't
with
tell me
plumbing.
don't tell me what someone else told you.
Oh, sorry. Well, it's not adequate. I was trying to figure out why the place kept flooding, and they said that's not the type of plumbing that's supposed to be in a commercial building.
Stuff on the wall. Is that mold flooded in there?
Yeah, multiple times.
Any other pictures?
No, here's the picture of the code and.
You said the roof caving in,
Yeah.
but you don't have a picture? Did you talk to him about the roof?
Yeah, many a time. Oh, so that's the.
The tenant presents evidence of chronic plumbing failures causing repeated flooding and mold growth, but the judge excludes hearsay testimony about a plumber's assessment. The tenant also references the August lockout text message as corroborating evidence. Michigan Rule of Evidence 801 defines hearsay as an out-of-court statement offered to prove the truth of the matter asserted, generally excluding such testimony unless an exception applies. Under Rule 703, expert opinions may rely on inadmissible facts or data if experts in the field reasonably rely on them, but lay witnesses cannot repeat others' conclusions. The business records exception under Rule 803-6 would permit maintenance records or repair invoices, but informal conversations with unidentified plumbers remain excluded. The judge properly sustained an implicit hearsay objection, preventing the tenant from testifying what someone familiar with plumbing said about pipe adequacy. This ruling limits the tenant to his own observations, flooding frequency, mold presence, water valve operation, rather than the more damaging conclusion that the plumbing was not supposed to be in a commercial building. The tenant's remaining admissible evidence still establishes a pattern of water intrusion that may support habitability claims, but without expert testimony, he cannot prove the plumbing was inherently defective rather than simply aged or poorly maintained. Eviction court's informal atmosphere often masks strict evidentiary rules that disadvantage unrepresented litigants. Tenants with legitimate complaints frequently lose credibility when their testimony strays into inadmissible hearsay, not from dishonesty, but from unfamiliarity with legal boundaries. Another argument for expanded right to counsel programs.
Text message with the code for access to the
Oh,
building.
that was back in August.
Kind of swipe up and go to photos, you'll see
What kind of business are you running out of here?
it's an e-commerce automotive parts, so we do a lot of shipping.
Show me where you communicated with him about the hole in the roof.
It was over the phone last year, once this year, I don't know the exact date.
So the
It's an
hole in the roof
ongoing
is not
issue.
new.
No, it's an ongoing issue.
Like, how big is this hole?
I want to find it for you because I actually had someone come up and caulk those holes.
Is the young
I
man-
had the hubcap that was used to cover the hole as well as the hole in my records.
And the young lady you have there, she works for this company as well?
Yeah. and
Okay,
she was
and
with-
she is aware also of the condition of the property?
Yeah, she has pictures in her possession as well, and she may have the whole picture.
Well, then she needs to send it to you, because I can't see Zoom. If she in fact has evidence, now is the time to present it. I'm not adjourning this. We need another week. This is my doctor. You said you need one more week to get one.
Well,
wanna
we
reset for a
defaulted him
week,
because
or-
he was here. We didn't know he was here.
Got it.
I spoke with him. Nor
The tenant describes an automotive e-commerce business and attempts to establish ongoing roof complaints through phone conversations. The judge learns a witness possesses additional photographic evidence, but cannot access it during the hearing, while the parties appear to reach a brief continuance agreement. Under Michigan Court Rule 2.506, parties may stipulate to continuances, and judges retain discretion to grant additional time for good cause shown. The rule balances efficiency against fairness, recognizing that evidence discovery and witness availability often require scheduling flexibility. However, repeated continuances may prejudice opposing parties and violate the just, speedy, and inexpensive determination mandate of Rule 2.108. The judge's apparent agreement to extend to June 16, 2026, reflects discretionary case management under Rule 2.506, allowing the tenant to obtain witness photographs and potentially organize his evidence. This continuance also preserves the possibility of settlement, which the judge earlier encouraged. The tenant's representative's statement, "I'm not joining this," suggests some disagreement about the extension terms, possibly indicating the tenant sought more time than granted or objected to conditions imposed. Continuances in eviction court operate under acute time pressure. Every delay extends a tenant's uncertainty while potentially accruing additional rent obligations. Judges must balance plaintiffs' property rights against defendants' due process interests, often with limited information about whether requested delays are genuine evidence gathering or tactical stalling.
he said he agreed another week.
Oh, we'll have to
9th
go on the
Turn
record.
to the 16th, I think.
We'll have to go on the record, and so it might be.
So your signature.
Yeah,
Oh, okay, come back up. Show them the evidence.
relative to the actual hole.
Who came to fix it? How is this evidence that he came to fix it if it doesn't tell you when?
Because it's a text message, but I just took the picture out of the text message so it would be easier to
Okay,
refer to.
got it.
Found the cat June 24th, so it would have been
June 2026, 25, it's fixed in June of 2024. So is that a yes?
yes, ma'am. I'm sorry.
Why are we talking about it now then?
Because it was
What was the damage to?
raccoons got in it.
So there was damage to some headlights, and how much was that, did that cost?
I never replaced it, but I would just do what headlights sell for.
Okay, how many headlights are we talking about here?
Wasn't very many. Anywhere from between low end 300, high end 750.
Okay, so you're not, okay. Any other damage or issues?
Flooded damage to electrical components that were in boxes from big flooding.
You said it flooded in there?
The court examines text message evidence of repair attempts, with the tenant establishing that roof repairs occurred in June 2024, 2 years prior to the hearing. The tenant then quantifies raccoon damage to automotive inventory and confirms annual flooding from plumbing failures. Under Michigan compiled laws section 600.5805, The statute of limitations for breach of contract claims is 6 years, while tort claims generally carry 3-year limitations. However, the doctrine of laches may bar claims where delay prejudices the opposing party, even within statutory periods. For habitability claims, the continuing violation doctrine allows recovery for ongoing conditions, but discrete damages from specific incidents may be time-barred if not promptly asserted. The June 2024 roof repair, 2 years before this June 2026 hearing, falls within limitations periods, but the tenant's failure to document intervening complaints weakens his claim of ongoing breach. The annual flooding pattern, confirmed under oath, establishes a continuing violation that supports both defensive claims and potential counterclaim damages. The quantified inventory damage, 300 Nash 750, provides concrete, admissible damages that could offset rent arrears under the doctrine of recoupment, even without formal counterclaim. Eviction court's accelerated timeline often compresses complex damages analysis into minutes, with judges making rapid credibility assessments about which conditions persisted and which were resolved. The tenant's scattered documentation, text messages, photos on others' phones, unrecorded phone calls, illustrates how informal business relationships generate poor litigation records, disadvantaging legitimate claimants.
When's the last time it flooded?
I have no recollection, maybe
Okay, how often have you dealt with flooding?
usually once a year, typically, something in that.
Plumbing related, not like weather related?
No, it's plumbing related.
And to your knowledge that, okay, what else?
Storage of the properties that I'm renting, and now they're becoming a problem.
He sued you?
Now, yeah, this hearing, him
Oh,
suing me. He said-
For what?
He's suing me now, but I was saying that his vehicles have been on the building that he's renting me, so he's telling me that it's okay for his vehicles to be on the property that he's renting me before, and I have.
Vehicles, how many vehicles you talking about?
He has about 5 vehicles on the property.
He's
For work or pleasure or leisure.
Oh,
Yeah,
okay. What type of vehicles you talking about?
So he has an older vehicle that wasn't running that he removed a week prior. Mine just been there for years. He removed that a week prior to, he has his own personal vehicle that's been there, and he has a mobile home. due
I'm
to
sorry?
Heating bills being inflated due to not having any installation in a home.
You provided him evidence of this?
I told him in the year that the lease was signed that I received a $5,000 heating bill from Consumers Energy due to the type of efficiency. I thought it was actually a typo, but the Consumers Energy came, so we run electric,
With no roof? Let me see here.
as well as.
When did
the
you move
lease.
in this property again? 2013. The furnace hasn't been replaced? 13 years?
Nothing has been.
So when you moved in, there wasn't a hole in the roof, but it became a hole over.
The tenant raises new claims about the landlord storing 5 vehicles on the property and a $5,000 heating bill from inadequate insulation, then contradicts the landlord's testimony about the roof hole's origin, establishing it existed at move-in and was covered by a hubcap for approximately a decade. Under Michigan-compiled laws Section 566.132, the statute of frauds requires leases for terms exceeding 1 year to be in writing, though partial performance may enforce oral agreements. The as-is doctrine generally allocates pre-existing defects to tenants who accept possession with actual or constructive knowledge, unless fraud or concealment is shown. However, the implied covenant of quiet enjoyment and constructive eviction principles protect tenants from conditions that substantially deprive them of beneficial use, regardless of lease disclaimers. The hubcap revelation fundamentally alters the habitability analysis. If the landlord knowingly concealed a roof penetration with an improvised cover rather than proper repair, this constitutes more than passive neglect. It suggests active concealment of a structural defect. The 10-year duration of this repair method undermines any claim that the tenant caused or assumed risk for the condition. Combined with the $5,000 heating costs from inadequate insulation, potentially violating energy disclosure requirements under MCL 554.634, the landlord's property management practices appear systemically deficient. This testimony transforms the case from tenant-caused damage to landlord concealment of latent defects. If credited, it establishes a pattern of cost-cutting maintenance that endangered tenant inventory and imposed excessive utility costs, potentially supporting claims for constructive eviction, breach of implied warranty, and even fraud that could survive beyond the eviction proceeding.
Time.
No, the hole was there, and I asked him what it was. And
Oh.
he told me it was a hubcap, same hubcap that was there. So that hubcap had been up there before we replaced it, or rather before the raccoons knocked it, maybe 10 years. So what he told me was that the tenant prior to me had a wood, it needed a chimney. Chimneys, you buy a cap that caps it off so things can't get in. 57 Chevy invertedly to cover that hole, which I mean, it just didn't hold up. Also, I have this generic lease that I don't know what's going on with. I don't have a signature of it. This is what they sent me. I never even signed a lease in my personal. I was having business in my business name and I wanted to put it under my LLC.
Okay,
which
so you
my
never
sense-
signed the lease?
No, I signed the lease then.
Oh,
Yep, I
just
signed the
not in
lease
your
then.
name.
I did not sign it in my name.
Got it.
Hence why we have a lease that's unsigned because it's limited in my name. It's suing me.
Got it. So where did you get this paperwork from?
This was the paperwork that came with the court paperwork.
Oh,
that
so
he
you're saying
presented.
that the lease that was attached to the court paperwork is not the actual lease?
Not the lease that I signed for me, Your Honor.
You can have a seat. You can respond. You can have a seat.
Appreciate that.
You can respond.
That is true, Your Honor. I asked if we could, if this lease was, I think, signed in 2014. I couldn't get a copy of the signed lease, but
The tenant reveals that the lease attached to the court filings is unsigned and differs from what he executed, raising questions about the document's authenticity. The landlord admits the filed lease is a 2014 template without signatures, obtained because the original signed lease could not be located. Under Michigan Court Rule 2507, pleadings must be verified or supported by affidavit when jurisdictional facts are contested. The best evidence rule under Michigan Rule of Evidence 1002 requires original documents to prove content, though duplicates are admissible unless authenticity is disputed. When a party cannot produce the original signed contract, Michigan courts apply the lost document exception under Rule 1004, but the proponent must explain absence and provide secondary evidence of terms here, an unsigned template with disputed applicability. The landlord's admission that he filed an unsigned 2014 template, as the lease creates a fundamental evidentiary problem, he cannot prove the terms under which the tenant currently holds possession. If the actual signed lease contained different repair allocations, rent amounts, or duration, the entire eviction premise may rest on incorrect contractual assumptions. The tenant's testimony about attempting to transfer the lease to his LLC suggests the original document may have contained personal guarantees or different entity designations that affect both parties' rights. This documentary failure exemplifies why commercial landlords maintain rigorous lease files. Without the signed original, the landlord cannot establish the agreed rent, term, or tenant obligations. The tenant gains substantial leverage. Any lease term favorable to the landlord is now unprovable, while the tenant's testimony about conditions and agreements becomes unrebutted by documentary evidence.
both parties did sign, but it's obviously not leased with the signatures on it. So I did the best I could to, it's a very generic, very simple lease, Your Honor. It's obviously it looks like something that was probably crafted by Mr. Markovitz. In any event, commercial buildings, the tenant is responsible for utilities. The reason there is water apparently problems in this building is because there isn't any heat in this building.
There is no heat in the building?
Yeah, well, as far as I know, the utility company has never turned on the heat in that building. So
Okay, the utility company never turned on the heat in the building. He said he got a $5,000 bill.
Prior to the 10 years. Early on, when he first got into the place, he got a real high heat bill. So I went ahead and insulated the ceiling for him at my own expense.
I can see where those things are down. It looks like there's some, in those pictures, there was some insulation there.
Yep, there's a lot of insulation. It cost me a lot of money.
Yeah, but what about the furnace issue?
The landlord defends against habitability claims by asserting tenant responsibility for utilities and describing self-funded insulation improvements. Under judicial questioning, he insists the furnace is commercial grade despite the tenant's residential unit characterization, citing prior tenant usage as evidence of adequacy. Under Michigan compiled laws section 554.139, residential landlords must maintain premises in reasonable repair and comply with housing codes, but commercial lease obligations are contractually determined. The prior use defense that previous tenants accepted conditions generally fails under Michigan law if the condition violates building codes or renders premises unfit for intended use. Under Bianchi-Villadner, 455 MIT, 489, 1997, prior tenant acceptance does not waive statutory protections or establish that conditions meet objective habitability standards. The landlord's reliance on prior tenant Kevin Reese's usage of the furnace is legally irrelevant to whether the unit meets commercial standards for the current tenant's e-commerce automotive business. The judge's precise questioning about residential versus commercial furnace specifications suggests concern that an improperly sized or vented unit could create safety hazards regardless of prior operation. The landlord's admission that he personally installed insulation, rather than addressing the root cause of heat loss, may indicate inadequate response to a systemic building envelope failure. Commercial tenants' rights often depend on precise lease language and building code compliance rather than broad habitability warranties. Here, the furnace classification dispute could determine whether the landlord violated energy efficiency standards or fire safety codes, violations that would support tenant defenses regardless of lease disclaimers, as courts cannot enforce contracts for illegal purposes.
The furnace is the same furnace that's in there, he just doesn't turn it on.
This is the furnace that was supposed to be for an apartment, correct?
It
A
worked
residential
fine.
unit?
It worked fine before he got into the
I'm not
building.
asking you how far, when it worked fine. That's not my question.
Oh,
This is a unit that's supposed to be for residential use.
no, this is a commercial furnace and it was set up for commercial property.
And
And
prior
it's-
to 2013.
Yeah, prior to 2050, it was all installed long before. The
And
tenant
yeah,
before him used it, Kevin Reese.
I'm sorry?
Kevin Reese is the prior tenant to that, and that's what he used.
Okay, I don't care who used it prior to. I want to know if it's supposed to be in a residential unit or it's supposed to be in a commercial property.
Commercial outfit.
It's a commercial outfit. Okay, and you have evidence of that.
How would I even know anything that I bring with me?
No, I'm asking you, I'm not saying you have it on you right
I've
now.
installed myself furnaces for Lansing Mechanical for a number of years, so I can tell you right now that it's a commercial unit.
What kind of furnace is it?
I can't tell you what it is right now because I can't remember. It's been so long since I've seen it.
So you don't even know what kind it is, but you're telling me for sure it's for commercial.
I'm telling you, he doesn't pay his heat bill.
I'm not
the
asking
damage
that,
to the
you're
building.
answering my
I
question. You're
cannot
telling
remember it
me,
This time,
okay, but you're for
Look.
sure that it is for commercial.
that's correct.
Okay, and so, did he ever contact you about a concern about the heat bill?
Just
Under sustained judicial examination, the landlord cannot identify the furnace manufacturer or model, undermining his categorical assertion of commercial suitability. He admits the sole response to the tenant's $5,000 heating complaint was insulation installation, and defends vehicle storage as shared parking arrangement. Under Michigan Rule of Evidence 7-on-1, lay opinion testimony is limited to opinions rationally based on perception and helpful to understanding. The landlord's commercial unit conclusion without specification crosses into expert testimony requiring foundation under Rule 702. The Federal Trade Commission's cooling off rule and Michigan consumer protection laws require clear disclosure of shared facility obligations, though commercial leases generally receive less regulatory protection than residential agreements. The landlord's inability to identify the furnace model, despite claiming installation expertise, destroys his credibility on the commercial adequacy issue. His admission that insulation was the sole remedy for extreme heating costs suggests either willful blindness to equipment inadequacy or deliberate cost shifting to the tenant. The shared parking characterization of 5 landlord vehicles on tenant-leased premises raises potential constructive eviction claims if parking availability was material to the lease agreement and has been substantially impaired. This exchange demonstrates how lay witnesses damage their credibility by overstating certainty on technical matters. The landlord's retreat from specific claims to general assertions, commercial outfit, mirrors the tenant's earlier hearsay problems. Both parties struggle to prove technical conditions without documentary or expert support, leaving the court to decide habitability based on incomplete and conflicting lay testimony.
early on when I insulated the place back before.
Okay, so that was how you addressed it by adding insulation.
Correct.
Vehicles, are you storing vehicles there?
This is a multi-tenant facility, so it's all shared parking.
Okay, so you use that property too? It says,
You like to look up on
You're
Google
saying-
Maps.
I'm sorry?
If you want, you can look it up on Google Maps.
I don't need to look up on Google Maps to see if you're storing your vehicles.
I just
there.
want to say I'm not a liar. And
Okay.
I try to be as honest as I can be.
What about the hubcap on the
So
chimney?
that was placed on there by Kevin Reese, the prior tenant. It's been on that. See, it was a chimney vent, like he explained, for wood stove, so they have added heat to the place. And that hubcap's been up there for years, and it's never given us any problems. And if it's missing, because maybe of a windstorm or something, that he may, or maybe he knocked it down, I don't know. But that's only a 6-inch hole for exhaust stack. And it is protruded up, so there's no water leaking into it. And the cap was what fit on there, and that's what we used, and it's been there for many years. There's no holes in the roof, there's no flooding of the
Why didn't you get a
property.
proper chimney cap?
Oh, that's what we had at the time, and it wasn't an issue, so I could have done better, yes.
Okay, so, it's possible.
The landlord admits to padlocking the tenant's commercial space, claiming it was unofficial and necessary because the building was left open. The tenant's attorney challenges this characterization, suggesting the text messages show rent was demanded before access was restored. Under Michigan compiled laws section 600.5744, any act by a landlord that prevents or deters a tenant from entering leased premises constitutes an unlawful lockout, regardless of whether the landlord uses the term lockout or claims good intentions. The statute explicitly prohibits self-help eviction methods, including padlocking doors, changing locks, or otherwise restricting access, even temporarily. In the 1978 case of Michigan Mobile Home Park Association v. Township of Waterford, the Michigan Court of Appeals emphasized that the statutory prohibition is absolute. Courts do not inquire into the landlord's motives or the tenant's conduct when determining whether a lockout occurred. The landlord's admission that he placed a combination padlock on the tenant's door during business hours triggers the statutory prohibition regardless of his stated purpose of securing the building. The timeline becomes critical here. If the landlord demanded rent discussion before providing the combination, this transforms a technical lockout into a potentially coercive act. The statute makes no distinction between official and unofficial lockouts. The act itself is what matters. The judge's questioning about whether money was discussed before or after the code was provided directly targets this statutory element. Landlords frequently attempt to characterize lockouts as security measures or temporary inconveniences, but Michigan law treats any deprivation of possession as a serious violation that can result in damages, attorney fees, and dismissal of eviction proceedings. This case illustrates how a landlord's admission of padlocking, combined with contemporaneous rent demands, can undermine their entire legal position, even when substantial rent arrears exist.
That a windstorm could have blown that off and an animal could have gotten this chimney. Did he call you that?
It's a really high pole barn, so I don't know how they would get up there.
No landscape.
They could get on the,
Steel roof, so I don't know.
it's a steel roof.
Yeah,
There are trees behind this property.
yeah, there's some trees, yeah.
He's talking about some plumbing and flooding.
So the plumbing and the flooding he's having is because he doesn't heat the bathroom. It has its own heater, but he doesn't turn it on. The plumbing, when you freeze plumbing, it's gonna break, no matter what
So
you
you're
do.
saying the pipes are bursting?
Yes. I've had to fix them numerous times, and each time I tell them, you gotta keep heat in the bathroom if you're gonna have water on.
Lockout.
That wasn't a lockout. The building was unlocked the one day. I put a padlock on there because I couldn't lock it any other way. And I left my phone number and everything on there for them to call me immediately. And then
The landlord attempts to justify the padlock by claiming the tenant had blocked his communications for 2 years, but the judge cuts through this explanation to focus on the core issue: the connection between restricting access and demanding rent. The timeline shifts to August 2026, with conflicting accounts of when rent was discussed relative to restoring access. Michigan Court Rule 2.507 governs the admissibility and weight of documentary evidence in civil proceedings, requiring that exhibits be authenticated and relevant to be considered. More specifically, Michigan Rule of Evidence 901 demands that evidence be sufficient to support a finding that the item is what the proponent claims it is. Text messages present unique authentication challenges under People v. Smith, 2015, where the Michigan Court of Appeals held that electronic communications must be shown to have been sent by the purported sender, either through direct testimony or circumstantial evidence, including context, content, and reply authentication. The tenant's attorney references text messages that allegedly contradict the landlord's testimony about the sequence of events, specifically that rent was demanded before the combination was provided. Under Rule 901, these messages would need authentication through testimony that the landlord sent them, which his own statements may effectively provide. The judge's methodical questioning about chronology, "Before you, I did not," suggests she is building a record to evaluate whether the documentary evidence undermines the landlord's credibility on the lockout timing. In landlord-tenant disputes, text messages often become the decisive evidence because they capture contemporaneous communications in ways that testimony months later cannot. The authentication requirements exist to prevent fabrication, but once satisfied, electronic communications can be more reliable than witness memory. Here, the discrepancy between the landlord's oral testimony and his written messages could determine whether the court finds an unlawful lockout occurred and whether the landlord's entire eviction case fails as a result.
So,
I
It's
just
not
saw the
official
I
lockout.
saw the text messages that you required a payment
It's not an official lockout.
before you
I did not. I locked,
get sent the
unlocked the
code.
building. They got the code right away before he even got any.
That's
money.
not what the text message showed.
Yes, but I had no way to contact him for 2 years. He
What do you
blocked,
What do
he
you
blocked me.
Okay, so what does that got to do with the property, you locking out of the property?
It was because the building was unsecured and I secured it.
It was unlocked for 2 years?
No, just the one time I put the padlock on it. And then
So
it was
you
a
said
combination.
but you said you shared use of this property, it's a multi-tenant and you're there. How come you didn't see him?
Because he's never there.
Okay,
He's
And-
suspended by the state of Michigan for selling auto parts.
and you
right now.
can't, and you couldn't leave a note or any
I did
contact?
leave a note. I wrote it right on the thing.
So you're saying one day you went there and the property was open?
Mhm.
Is that a yes?
Yes.
Okay, what day, this was in August?
The judge conducts a detailed factual inquiry into the nature of the lock, the circumstances of its installation, and the landlord's presence on the property. The landlord's admission that he walked through the tenant's space without permission adds another potential violation to the record. Under Michigan compiled laws, Section 554.634, a landlord's right of entry is strictly limited to specific circumstances, making necessary repairs, supplying necessary or agreed services, showing the premises to prospective tenants or purchasers, and addressing emergencies. The statute requires that entry be at reasonable times and, except in emergencies, that the landlord provide at least 24 hours notice. Entry without notice or consent, particularly when combined with a lockout, constitutes a separate breach of the statutory covenant of quiet enjoyment, as recognized in Javins v. First National Realty Corp. 428 F.2d 1071, D.C. Sur. 1970, which Michigan courts have adopted as persuasive authority for the implied warranty of habitability and peaceful possession. The landlord's casual admission that he walked through the tenant's commercial space demonstrates a fundamental misunderstanding of statutory entry limitations. Even if the door was open, the landlord had no right to enter without the tenant's consent or proper notice. This unauthorized entry, combined with the padlocking, suggests a pattern of interference with the tenant's possessory rights that extends beyond the single August 2026 incident. The judge's questions about why the landlord was present and what he observed indicate she is evaluating whether the landlord's conduct violated the statutory framework governing landlord-tenant relationships. Commercial tenants often mistakenly believe they have fewer protections than residential tenants, but Michigan's entry restrictions apply broadly. A landlord who treats leased premises as their own property, entering at will, installing locks, and restricting access, undermines the fundamental premise of leasehold, the tenant's exclusive right to possession. Courts view such conduct as particularly egregious because it represents self-help remedies that the legislature has explicitly prohibited, recognizing that allowing landlords to take possession into their own hands invites abuse and violence.
August of this
I
year?
don't remember when it
This
was.
was in August of this year, obviously, because I
He
saw
has
the
the
text
picture,
message.
so.
And
I left my
so,
name and phone number right on
so you reached out and said,
there. Since I had him on the phone, I talked to him about rent. Of course, I gave him the code right away, so they can get back in there. Because they're not there all the time. They're only there.
what kind of lock is this? It was a padlock?
Yeah, just a little combination.
You put a combination padlock on there
You seen the picture?
because because it was left unlocked?
left open,
Left open?
yeah. Unlocked, open,
Is it a door that opens and shuts?
yeah.
Okay, and you don't have a key? And so the only way to lock it was to put a padlock on there is what you're saying?
Yeah,
Yes?
for me,
Oh,
yes,
for you, this was during business hours?
yes.
Why were you over there that day? To see that it was unlocked?
The landlord's testimony becomes increasingly disjointed as he admits his problem was needing to discuss rent, revealing that the padlock served as leverage to force communication. The judge intervenes to maintain order and redirect the landlord to answer questions directly rather than volunteer explanations. Michigan Court Rule 2.108 governs the conduct of proceedings in district court, authorizing judges to exercise reasonable control over the mode and order of examining witnesses and presenting evidence to make those procedures effective for determining the truth. This includes limiting testimony to responsive answers and preventing narrative responses that evade questioning. Additionally, the rule reflects the broader principle that witness testimony in court proceedings is distinct from casual conversation. Answers must be precise, and attorneys, or self-represented parties, must be given opportunity to develop the record through structured questioning. Judge Simmons demonstrates proper judicial management under Rule 2.108 by stopping the landlord's rambling explanation and reminding him of his attorney's presence. The landlord's statement that he needed somebody to talk to so I can at least talk about rent is the critical admission. It establishes that the padlock was not merely a security measure, but a deliberate tactic to compel rent negotiation. The judge's insistence on chronological clarity, "You can't mix it up with me," shows she recognizes that the landlord is attempting to conflate events to obscure the temporal relationship between the lockout and the rent demand. Judicial control over witness testimony serves two essential functions. It protects the record from confusion that could lead to reversible error, and it ensures that parties, particularly self-represented ones, receive fair opportunity to present their cases without being overwhelmed by opposing narratives. Here, the judge's intervention preserves the integrity of the fact-finding process while also protecting the landlord from himself, as his volunteered statements increasingly damage his legal position.
I'm there all the time. So I got multiple buildings there in this property.
So you just went by to see
I was
him
trying
and
to
the
get a
door
hold
was
of
open?
them.
And the door was open?
Yeah,
Or
and I walked through and there's nobody there, so.
So you locked it?
Yeah.
And then how long from the time you locked it before you heard from them?
The next day.
The next
Well,
day,
actually, it might have been the same day, actually.
same day?
Yeah.
And then he called you?
She called me or somebody called me.
Okay, someone called you.
Why is there a padlock on the door? I said, blah, 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 blah.
You said what? I don't know, we don't blah, 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 blah in court.
Oh, the place is loud.
Seinfeld episode.
Yeah. You said what?
Do you have a cup of water? My mouth is so dry right now.
You do not have a cup of water, but someone maybe can get you a bottle of
Oh,
water.
that'd be awesome. Anyways, yes, I explained that the building was unlocked or open and
So you wanted to secure their stuff?
well,
is
I
that-
want to secure my building.
Okay.
I don't want to leave it open. So anyways,
And he said, here's the code.
well, here's my problem. I got nobody to contact and you're not
Sir.
there. You're not there. You're not there. So I need somebody to talk to so I can at least talk about rent he's behind. I mean, he's got $48,000 in the bank account and he can't pay rent. So I don't know.
So that's what
Under direct questioning from the judge, the landlord explicitly denies that rent was discussed before the combination was provided, directly contradicting his earlier admission that he needed to talk about rent and that the situation worked out as a combination of stuff. The landlord's attorney then shifts to redirect examination, focusing on the tenant's payment history and failure to escrow rent. Michigan Rule of Evidence 607 permits any party, including the party who called the witness, to attack the witness's credibility. A witness who provides contradictory statements on material facts may be impeached by either statement, and the trier of fact determines which version, if either, to credit. In People v. Barrera, 451 Mich. 261, 1996, the Michigan Supreme Court held that prior inconsistent statements are admissible not merely to impeach, but as substantive evidence when they meet specific reliability requirements. For bench trials, the judge serves as both gatekeeper and fact-finder, weighing contradictions against other evidence to determine credibility. The landlord has now provided at least 3 different accounts of the August 2026 incident. 1, that he gave the code immediately when contacted with no discussion. 2, that he needed to talk about rent and the situation worked out as a combination of stuff. And 3, that he gave the code before money was discussed. These statements cannot all be true. Under Rule 607, the tenant's attorney could introduce the text messages or the landlord's prior admissions to impeach his trial testimony. The judge, as fact finder, must now determine which version, if any, reflects actual events, with the contradiction itself weighing heavily against the landlord's credibility. Credibility determinations often decide landlord-tenant cases because direct evidence is rare and circumstantial evidence requires witness interpretation. When a landlord's testimony shifts under pressure, courts infer consciousness of wrongdoing, particularly when the shifting explanations track the legal elements of prohibited conduct. Here, the landlord's retreat from his rent discussion, admission to a no-discussion denial, suggests he recognizes that conditioning access on rent payment constitutes an unlawful lockout, and his attorney's pivot to payment history indicates a strategic recognition that the lockout claim may defeat the eviction regardless of arrears.
You talked about back in
No,
August.
no,
Oh, okay.
I'm
You called
mixing
because you
up
put a
the story.
padlock. Yeah, you can't mix it up with me because I'm following a story here.
Yeah, I'm trying to
So,
explain it, but
okay.
I'm way nervous and it's hard to.
Why? You got your attorney right here.
Well,
So just answer the questions.
okay.
You you blocked it because it was unlocked. They called you same day and you said, hey,
Here's your combo. Here
here's
you
your
go.
combo.
But how do I?
But
get
wait,
hold
how do I
of
get
it?
my rent?
Yep. How do we take? Yeah.
And
It kind of worked out as a combination of stuff. So
okay, and what did they say about their rent? About your rent?
I don't remember then.
You don't remember that?
No, I don't.
Okay. But then this conversation must have continued via text message. It must have, because I saw the text messages
Okay.
where you were telling them how much the rent was.
Yep.
And that you wanted some money by a certain point,
Mhm.
to which they responded. And then you sent the code.
Yeah, but they never, they didn't pay that rent they said they were gonna pay, so what do you want me to do?
No, I'm talking about the order in which you gave the code.
However, the combination came out is how it worked out.
She's asking you whether or not you gave the code in exchange for money. So
Oh,
did you
no.
receive money at that time?
No, I
for
gave the
rent?
code before money was even discussed.
Okay.
The landlord's attorney attempts to establish a pattern of non-payment unconnected to any repair issues, while the tenant interjects to challenge the rent ledger's accuracy. The judge firmly maintains courtroom order, directing the tenant's attorney to wait for her questions and correcting procedural assumptions about standing and document handling. Michigan Court Rule 2.506 establishes procedures for presenting documentary evidence in civil proceedings, requiring that exhibits be marked, offered, and admitted before consideration. The rule works in conjunction with Michigan Rule of Evidence 1002, the best evidence rule, which generally requires production of the original writing to prove its contents. However, Rule 1004 provides exceptions when originals are lost, destroyed, or unobtainable. In Bianchi v. Ladner, 455 Mich. 489-1997, the Michigan Supreme Court emphasized that trial courts have discretion to admit secondary evidence of documentary contents when the original's absence is adequately explained, but the proponent bears the burden of establishing the substitute's reliability. The landlord's reference to a spreadsheet of all the payments triggers both authentication and best evidence concerns. Under Rule 2.506, the spreadsheet must be properly offered and admitted before it can be considered. The tenant's challenge. I asked for that ledger multiple times, suggests potential discovery violations under Michigan Court Rule 232, which requires disclosure of documents relevant to disputed facts alleged with particularity in the pleadings. If the landlord possessed this spreadsheet throughout discovery but failed to produce it, the court could impose sanctions including exclusion of the evidence. The judge's focus on the chronological relationship between payment history and repair complaints indicates she is evaluating whether the tenant's non-payment constitutes a legitimate defense or mere breach. Rent ledgers are frequently dispositive in eviction proceedings, but their evidentiary value depends entirely on proper foundation and disclosure. Landlords who manipulate payment records or withhold them strategically undermine the judicial system's ability to resolve disputes fairly. The tenant's claim of inconsistent access to the ledger raises concerns about procedural fairness that may affect the court's assessment of the landlord's overall credibility and compliance with discovery obligations.
And then, these are all my questions for him. Did you have any?
So was that, all right, so we're talking $14,300 in back rent.
Right.
Has he ever put any money into any rent into escrow or anything else? Did he ever set up a payment plan with you of some sort? At any point, did he say, if you fix X, Y, and Z, then I'll remit payment for my
No.
background. It's simply for a period of whatever, 10 months or whatever this is, you received no rent at all.
And I have a log sheet of, a spreadsheet of all the payments and,
Okay, and to be
Where
clear,
is this spreadsheet? Did you give it to your attorney?
he's got a copy of that, I believe, don't you?
Of like when he made payment, when he doesn't?
Yeah.
And he's been a tenant for about 13 years?
Correct.
Has rent been, always been an issue with you, or have you, was it a time where you were getting payments consistently and then it stopped?
Oh, he was consistent for a while.
Okay.
There's a record of it.
Excuse me, ma'am, may I add some clarity?
I'm gonna need some clarity about why you talking out on my radio. I need clarity now. I'm the only person here that needs clarity.
Oh, no,
You can go back on mute, man, because I do have questions for you at the appropriate time,
okay,
okay?
Two different ways. Would you like me to hand this to you?
Attorney for MLK, this is signed by two attorneys, so you're free to go. I never told you to stand up, to be honest.
Sorry. Yeah, I just assume you stand up for.
I just stand because I'm tired of sitting all day long.
Okay, so this goes back to
I changed over to
$1,200 a month.
21. It's only been raised one time and
There's lots of I have perfect eyesight, thank you. There's lots of months here that have zeros. Is that to reflect no
Yes.
rent received? Okay, and this would be 2020, 2021, 2022, prior to there being you reported an issue with the roof in 2024. This is all prior to that.
The tenant attempts to raise a rent increase dispute as context for payment difficulties, but Judge Simmons cuts off this line of argument as untimely and irrelevant to the current non-payment claim. The landlord confirms the tenant never achieved zero balance from 2021 forward, establishing substantial arrears throughout the relevant period. Under Michigan compiled laws section 566.132, lease modifications must be in writing to be enforceable if they fall within the statute of frauds, generally including agreements that cannot be performed within 1 year. However, even oral modifications may be enforceable through partial performance or equitable estoppel. More critically, Michigan law recognizes the doctrine of waiver by acceptance under Klein v. Pyrodyne Corp. 810 F. Sup. 1526 W.D. Mitch, 1992. A tenant who continues paying increased rent without objection may be deemed to have accepted the modification. The doctrine of lawz, while technically inapplicable to statutory claims, informs judicial discretion in evaluating delayed challenges to rent increases. Judge Simmons correctly identifies that any challenge to the 2021 rent increase is procedentially barred by the tenant's failure to contest it contemporaneously. The tenant's continued occupancy and partial payments from 2021-2024 constitute acceptance by conduct under Klein, particularly given Michigan's recognition that commercial tenants bear greater responsibility for documenting lease terms. The judge's directive, "We can't come 5 years later," reflects the equitable principle that parties must assert rights promptly or forfeit them, preventing tenants from weaponizing stale grievances to defeat current eviction proceedings. This ruling narrows the case to the documented arrears and the lockout defense. Landlord-tenant law balances formal contract principles against the practical realities of ongoing rental relationships. Courts refuse to let tenants accumulate unchallenged rent obligations while preserving speculative defenses, as this would destabilize the predictability essential to property management. The judge's ruling here teaches that procedural diligence matters. Tenants must document disputes and assert rights promptly, or risk having valid grievances deemed waived by conduct and time.
Or were you paying your rent prior to that?
I mean, there were months that I obviously failed, well, not obviously, but there were months that there were some hardship on rent, and we worked out an agreement. But also,
What agreement?
basically that I would pay the rent, whatever I'm behind. You know what I mean? As far
Did
as
you ever
2020
catch up? 'Cause
Yeah,
don't
I
see
did
where
catch
you
up.
did.
I caught up or got close to catching up. I'm not sure. I can't really tell. I asked for that ledger multiple times. He told me the day that we talked to the lawyer that he would send me a ledger or whatever. But
You
I
can get you a
never-
copy now if you want.
Yeah, I mean, and then I can compare it to,
So you don't remember ever being at a zero balance past due?
I'm sure I was, yes. Yes, I remember being zero balance past due and catching up on it. I
In
just don't have it.
2024, were you at zero?
I don't have a-
You don't know. Was he
I
at
don't have a
zero in
recollection.
2024?
I can tell you if I look at the
Okay.
sheet.
Yeah, opposed to that though, the rent agreement was because that he was behind on taxes and they were about to take.
None of
the
our
bill.
business.
I know, I understand that, but I was just telling that, I'm telling that to give the backstory of the increase. The increase wasn't ever an amended lease. It wasn't never a discussion to where I agreed to for this to be a permanent increase. This was
You were
more so
you were notified that there was gonna be a rental increase?
by him by mouth, and it wasn't called a rental increase. He said that they're getting ready to take the building because of taxes. So
So he had to up the
17,
rent.
12.
Was he at a zero balance in 2020? I mean, because this rental increase took place in like 2021. So we're not talking about that anymore. Because if that was an issue, you would have been in court or should have been at.
The landlord establishes a consistent pattern of arrears from 2021-2024, with balances ranging from $1,100 to $6,500. The tenant attempts to pivot to a settlement defense but lacks documentary support, and the judge expresses frustration with his failure to obtain counsel or prepare evidence despite multiple court appearances. Michigan Court Rule 2.112 requires parties to appear at scheduled hearings prepared to proceed, including having all witnesses and evidence available. The rule permits continuances only for good cause shown, which generally excludes lack of preparation when the party has had adequate notice. Additionally, Michigan's right to counsel in civil cases is limited. While criminal defendants have Sixth Amendment protections, civil litigants, including eviction defendants, have no constitutional right to appointed counsel. The quarter-point system referenced by the tenant applies only to criminal indigent defense under Michigan compiled laws, section 775.16. Not to civil proceedings. Judge Simmons correctly distinguishes between criminal and civil appointment of counsel, correcting the tenant's misunderstanding that indigent defense mechanisms apply to eviction cases. Her reference to legal services availability at pretrial reflects Michigan's efforts to provide access to justice through limited scope representation and self-help resources, but these do not substitute for full legal representation. The tenant's admission that he was preparing for a case while simultaneously claiming settlement defenses suggests inadequate preparation under Rule 2.112, particularly given his prior appearances without counsel. The judge's evident skepticism, that's not the truth, signals that she views his procedural explanations with diminishing patience. The access to justice gap in eviction proceedings represents one of civil law's most pressing challenges. Tenants facing displacement often cannot afford counsel. Yet the consequences of eviction extend far beyond housing to employment, credit, and family stability. While courts cannot manufacture representation, they can and must ensure that unrepresented parties understand procedural requirements and have fair opportunity to present evidence. Judge Simmons's detailed explanation of available resources, combined with her insistence on timely preparation, attempts to balance compassion for the tenant's situation against the need for efficient case resolution.
For a long time ago, saying he unlawfully raised my rent. We can't come 5 years later and say,
No, he was behind on rent on 2024. I can't read the amount.
did he ever come down? Was he ever at a zero past due in 2023?
No, he owed, here.
You can't see your own.
I'm sorry. I can show it. Oh, you know what?
What about 2021? Was he at a zero balance then?
21, he owed $1,100.
2022,
2022, he owed $5,000.
at the end of 2022?
Yes.
Okay.
And
And at the
then
end of 2023?
he owed $6,500.
Okay. And then 2024?
He owed $3,900.
So that's probably what you mean when you say you got close a couple times?
Not necessarily, Your Honor, because like I said, I asked for this ledger to compare it to the ledger that I would have had prepared for court to compare the numbers.
So
What
you
I told him
you
was
believe
that I
you
did
have a
not-
ledger that disputes?
Correct.
rent payments?
I do, because we had a lot of.
Where's your
payments.
ledger?
I don't have it.
Why not?
Because I wasn't,
This is for failure to pay rent. You're supposed to show me, no, I paid rent here.
no, I understand, but the initial case was for the settlement. Well, not the initial case, but this second day was for the.
No, the original, the case is about non-payment of rent. That's what the whole case is about. I'm addressing the settlement because you said that you had an agreement, and that you showed me text message that showed that if he accepted the payment, that eviction. I don't see where it was accepted. So we have to move forward with the case, which is why I was asking about your evidence.
Gotcha. No, I mean, if I was preparing for a case, I would have had.
No,
evidence
no,
for
that's
that.
not the truth. You came before without counsel.
I know, and when I came before without counsel, it was to say that I'm gonna need counsel because they're not agreeing to the settlement that they accepted.
Okay, so you have money to pay for an attorney, but not to pay your past due, right?
No, I do have money maybe to pay for an attorney if I can get like a court appointed attorney or something of that
You
nature.
don't do court appointments for civil. This is not criminal.
Oh, I don't know. But I was gonna try to source an attorney.
The tenant's attorney introduces a witness who challenges the landlord's account of the warehouse security, revealing that the space had ADT monitoring and remote locking capability, contradicting the landlord's claim that padlocking was necessary for security. The judge immediately identifies the logical inconsistency between lock and key and remote locking. Under Michigan Rule of Evidence 701, lay witnesses may testify to opinions that are A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact in issue, and C, not based on scientific, technical, or other specialized knowledge. This permits fact witnesses to describe security systems they have observed and used. Rule 702 governs expert testimony, requiring scientific, technical, or other specialized knowledge that will help the trier of fact to understand the evidence or to determine a fact in issue. The distinction matters because improper expert testimony from lay witnesses can constitute reversible error under People v. Kowalski, 492 Mitch, 106-2012. The witness's testimony about ADT monitoring and remote capabilities falls within Rule 701 as based on personal knowledge of the security system. However, her explanation of how remote locking interacts with physical lock and key mechanisms approaches technical territory. The judge's pointed question, "How can you lock it remotely if it's a lock and key?" reveals her recognition that the witness's explanation may require expert foundation under Rule 702, or may simply be internally inconsistent. The contradiction between the landlord's only way to lock it was a padlock testimony and the witness's always locked with remote capability account creates a credibility dispute that the judge must resolve based on the totality of evidence. Security system testimony frequently determines the outcome of unlawful lockout claims because it establishes whether the landlord's security justification was genuine or pretextual. Here, the emergence of contradictory evidence about remote monitoring and locking capabilities suggests the landlord may have had less intrusive alternatives to padlocking, strengthening the tenant's claim that the lockout was designed to pressure rent payment rather than protect property. The judge's active questioning demonstrates her role in testing witness credibility and ensuring the record supports whatever findings she ultimately makes.
You would have to hire an attorney. You have the option of meeting with legal services at your pretrial when we advise you of your right to appear with counsel. And I don't know if you met with legal counsel at the time or not. A lot of people don't do it, or they say, well, I'll do it later, even though legal aid has set aside the day to meet with them right then. And so today was the date reset, but you were supposed to have this evidence at the last court date. Your witness has some information or needs some clarity. Ma'am, can you unmute?
No, the clarity I was asking, well, not for me, was to give you, he was saying that it's a multi-tenant building. It's a large lot that has separate buildings. So for him to go and lock the warehouse, there's nothing of his that was in there for him to go and unlock or to check to see if there was a lock on there.
Was the warehouse unlocked?
That I'm not aware of. The warehouse is, if no one's there, the warehouse is always locked, and there is security on the warehouse, like an ADT monitor on there. So if it was unlocked, it could have been locked. If someone would, like, it can be locked remotely. So I'm like,
so it had a remote. You could remotely lock it. Is what you're saying.
There's a security setting on there as well. But what I'm saying is, like, there's.
So wait, what kind of door lock? Is it one that you could just press lock on it from the outside?
No,
okay.
It's a lock and key. But there's.
The judge continued her examination of the landlord's security justification, revealing that the warehouse door had a simple interior locking mechanism, a slam lock that allowed the tenant to secure the premises from inside without any padlock. This testimony severely undermined the landlord's claim that padlocking was necessary for security, as the tenant demonstrated he could lock the door himself when leaving. Under Michigan Compiled Laws Section 600.5744, Self-help eviction through padlocking constitutes an unlawful lockout regardless of the landlord's asserted security concerns, and courts examine whether the landlord's actions were genuinely motivated by security or were pretextual. The Michigan Court of Appeals in McKinley v. Hospod, 201 Mich. App. 527, 1993, held that landlords must pursue formal eviction procedures rather than taking possession matters into their own hands, and that security claims are viewed skeptically when less intrusive alternatives exist. The statute provides for statutory damages and attorney fees when tenants prove unlawful lockout, reflecting legislative intent to deter extrajudicial dispossession. Here, the emergence of testimony about the slam lock mechanism fundamentally alters the court's assessment of the landlord's security justification. The judge's pointed questioning, if he's inside and he locks it, how's he going to get outside? Exposed the practical reality that the tenant could secure the premises without landlord intervention. The tenant's testimony that you don't need a padlock, combined with the landlord's witness admitting unfamiliarity with the locking system, suggests the padlock served a coercive rather than protective function. This evidentiary development strengthens the tenant's claim for statutory damages under Section 600.5744 by demonstrating the availability of less restrictive alternatives. The distinction between genuine security concerns and pretextual lockouts determines whether tenants receive statutory protections and damages. When courts find that landlords had reasonable alternatives to padlocking, such as functional interior locks, they are more likely to conclude the lockout was designed to pressure payment rather than protect property, triggering significant legal consequences and deterring future self-help evictions.
No way that the building was just unsecured, that no one was there and he walked into the building.
Well, how can you lock it remotely if it's a lock and key?
I'm saying there's a security system on the building.
Okay.
Yeah.
So basically, the door would have been open, it would have alerted us.
Got it. Not that it could be locked remotely, but there was another security mechanism, what you're saying.
Yes.
But the door locked from the inside. It doesn't lock from outside. It's a regular door. You just twist it with your fingers. It wasn't locked. It wasn't open.
You said it locks from the inside.
Yeah, you don't need a key to lock it. It's not a deadbolt. It's just a regular.
Yeah, but if he's inside and he locks it, how's he gonna get outside? You mean
No,
like
you
a
just
slam lock? Like he lock it and he can leave and it's locked.
Correct. You can lock, like that's the same way I lock it. You can lock the door and close
And
the
then
door.
walk
You
out
don't
and
need a
close it.
padlock.
The landlord's witness testified about a purported settlement agreement where the landlord would accept $4,000 to stop the eviction while allowing the tenant to remain for several months. But the tenant disputed the amount owed, claiming $8,600 versus the landlord's current assertion of approximately $14,000. The judge began examining the documentary record to reconcile these competing claims about the debt amount and the agreement's terms. Settlement agreements in eviction proceedings are governed by contract principles requiring offer, acceptance, and consideration, with Michigan courts enforcing such agreements under Michigan Court Rule 2.507 when they represent meeting of the minds. Under Bianchi v. Ladner, 455 Mich. 489-1997, ambiguous contract terms are construed against the drafter, typically the landlord in residential and commercial lease contexts. The statute of frauds under Michigan Compiled Laws Section 566-2132 requires agreements concerning real property interests to be in writing, though partial performance may stop a party from asserting the defense. Critically, acceptance of payment pursuant to a settlement agreement typically constitutes accord and satisfaction under Michigan law, barring subsequent claims for the same debt. The testimony reveals critical ambiguities in the purported settlement. The witness stated the $4,000 would stop the eviction without washing away past due amounts, yet the tenant apparently understood this as resolution of the dispute. The judge's focus on documentary evidence, the December 9, 2025 complaint alleging $8,600 versus current claims of $14,000, suggests potential inconsistencies in the landlord's position that may affect enforceability. The tenant's reference to money being held through the payment services implies third-party payment processing complications that may excuse non-payment under the doctrine of tender, while the landlord's post-agreement eviction filing potentially constitutes breach of the settlement accord. Courts scrutinize settlement agreements in eviction cases to prevent landlords from extracting payments while reserving rights to continue eviction proceedings, which would render such agreements illusory. The discrepancy between amounts claimed at different procedural stages affects both the good faith of the parties and the validity of any judgment, as courts cannot enter money judgments for amounts not properly pled or proven.
Is that true?
I don't know, because I'm not familiar with the law, so.
Whose lock is it?
think it's his building.
There was definitely an unlawful law. I saw the text messages, so that's not even up for dispute. That was a shakedown. Anything else you wanted to share, ma'am?
Well, the second agreement that we sent that showed if he did not want to cancel the quit was the second attempt at payment. The first one it timed out and he requested another. He said that he called me and told me he was having trouble accessing the payment. And that's when I went on the app and saw that it had timed out. And so the last text message, which is the one that you saw, is me resubmitting it to him for him to accept the payment of the $4,000.
Were you the one who was talking to him about this agreement?
Yes.
To accept. Okay, what was the agreement, ma'am?
That he would accept the $4,000, so it would to stop the eviction, and that we would go forward with continuing the rent until that we found somewhere else for a warehouse, so we can just kind of terminate this once the weather broke, because it's too cold to try to move everything in the warehouse after all this time.
Okay, so that doesn't say that we're not, I'm washing your back past due amount. That's just I'm stopping the eviction.
But there was a discrepancy on the exact amount, because the initial amount from the eviction that was sent was only $8,000 from the original paperwork that was filed wasn't for the amount that he's now saying of the $14,000. So there's a discrepancy on the actual number of what is owed.
But this was filed in December.
I don't remember the date that this was, because Andy, it was said multiple times, explained that the money was being held through the payment services. As soon as money is released, then the rent will be paid, and that the money was there. And he had got several payments since he initially said that he was going to file. So that's why there's a discrepancy on the exact number that may be owed.
This was filed December 9th, 2025. It says rent was paid through March 2025, and that the rent due was $8,000.
The judge performed a mathematical reconstruction of the debt, determining that the original $8,600 complaint, dated November 24, 2025, and filed December 9, 2025, excluded December rent, and that adding December through February at $50,000 monthly yielded $13,700, resolving the apparent discrepancy between $8,600 and $14,000 claims. The attorneys then began discussing a potential conditional dismissal with payment terms. Under Michigan Court Rule 2.507, parties may stipulate to conditional dismissals where claims are resolved upon performance of specified conditions, with dismissal becoming final only upon satisfaction. The rule permits courts to retain jurisdiction to enforce settlement terms, ensuring compliance with payment schedules and move-out dates. Madden v. Borg-Warner Automotive, Inc., 448 Mich. 438, 1995, established that stipulations entered in open court constitute binding judicial admissions that preclude subsequent contradictory positions. For eviction cases specifically, conditional dismissals protect tenants from immediate judgment while providing landlords enforceable remedies for non-compliance, striking the balance that formal court oversight provides compared to informal agreements. The judge's calculation, $8,600 plus 3 months at $1,700 equals $13,700, establishes a stipulated baseline that both attorneys appear prepared to accept, streamlining resolution despite earlier confusion. The proposed conditional dismissal structure, $4,000 immediate payment, 90-day move-out period, extended payment plan for remainder, mirrors standard equitable arrangements in commercial eviction cases where immediate possession is impractical. The court's retention of the $4,000 in escrow pending formalization of the conditional dismissal ensures the tenant's performance is secured while protecting the landlord from further default, demonstrating how Rule 2.507 facilitates practical resolutions that informal settlements cannot guarantee. Conditional dismissals prevent the agreement today, eviction tomorrow scenario that occurs when parties rely on unenforceable oral understandings. By formalizing the settlement through court order with retained jurisdiction, both parties gain enforceable rights, the tenant against premature eviction, the landlord against non-payment, with the court serving as ongoing arbiter of compliance rather than requiring new litigation for breach.
$600. I'm assuming you didn't get, did you get December rent, or did that include December rent?
This existing payment now is all the way up till February. And
Did
then,
you hear my question?
I guess I don't understand your question.
There's a reason why I ask questions, because I want that answered. Did the $8,600 include December rent?
No.
Okay, And so, but okay, it said rent was due through, was paid through March 2025. So after filing this, which would have been December 9th, because their rent's due what day of the month?
First.
Okay, so I don't know why it would not include December because it was filed after the first, but nonetheless, you're saying that 1,700 for December, 1,700 for January, and 17 for February.
Originally, when we served them was back in August, I think, or September, I think it was.
Well, we're talking about when, from the time the notice to quit,
That's
it
where
said
the
the rent
8,700
due
came.
now. It says the rent due on December 9th is $8,600. I'm trying to see what $8,600 is plus 5,100, $13,700.
Yeah, but it was from, when we first, the 8,700 came from the first summons, to demand for rent.
Listen,
Do we have
it
that?
says this is what's due now.
Well, not that summons, the summons before that. There's two summons.
You're talking about the notice.
Yeah, the notice to quit, that's what it is.
I'm looking at a summons and complaint.
I guess I don't know what I'm,
Well, let's just,
I'm looking at a complaint. It says as of December 9th, they owed $8,600. That the rent is $1,700 a month. If I take that to your credit, that was actually, the court received it on the 9th of December, but it was dated November 24th. So December rent would not have been
it does take
included.
a little, takes
Yeah.
about 2 weeks to
Yeah.
e-file.
So December rent would not be. So if I add December, January, February to that amount, that brings me without any late fees, $13,700. How much is the late fee? I'm assuming the late fee has been assessed.
No, to be honest, we didn't add a late fee.
Okay,
As a matter
but
of
you're
fact,
saying the past due amount is 14,000 and what?
one of the state 300, 14,300.
There is some discrepancy there.
Well, I mean, if to speed things along, we'll stipulate to a lower amount.
And
I
so
don't want to argue over.
I would agree. So the original discussion was a conditional dismissal. They pay a certain amount and then pay towards the back end.
Yeah,
The judge clarified that the attorneys had drafted a consent judgment rather than a conditional dismissal, then admonished the tenant for failing to bring payment records to dispute the $13,700 debt, rejecting his request for additional time to gather evidence and check the landlord's ledger against his own electronic payment history. Under Michigan Court Rule 2.506, parties bear the burden of producing evidence supporting their claims and defenses at hearing, with courts generally denying continuances for evidence available through reasonable diligence. The rule permits continuances only upon showing of good cause, which typically excludes lack of preparation or failure to subpoena available witnesses. People v. Kowalski, 492 Mitch, 106, 2012. While a criminal case articulated the principle that judicial resources are squandered when parties appear unprepared despite adequate notice. In eviction proceedings specifically, Michigan compiled laws section 600.5744. 5 requires tenants seeking to contest rent amounts to provide reasonable proof of payment, with courts permitted to proceed on landlord's records when tenants fail to produce contrary evidence. The tenant's admission that he wasn't sure that I needed it today, and his reliance on his attorney's instruction to just bring the text message, demonstrates a fatal misunderstanding of his evidentiary burden. The judge's pointed questioning, "How are you keeping records?" reveals that the tenant possesses electronic payment documentation but failed to organize it for presentation, precisely the situation Rule 2.506 addresses by denying relief for self-inflicted unpreparedness. The court's refusal to reset this for any more time reflects the principle that tenants who dispute rent amounts must come prepared with organized proof, not vague assertions of electronic payment existence that require judicial time to verify against landlord records. Eviction courts handle high volumes with limited time. Permitting parties to delay proceedings for evidence they could have gathered earlier would collapse the system and prejudice landlords holding over tenants. The rule incentivizes proper preparation and ensures that disputes are resolved on actual evidence rather than unverified claims, protecting judicial resources and promoting finality in landlord-tenant relationships.
whatever the remaining rent, Andy was going to allow him to pay it over time, like over a couple of years, because he realized he was going to give him an additional 3 months to move out, just like the young lady said. because he has obviously a lot of time to get him out of the building. So,
Gonna give him 90 days to move out.
yep,
He's going to, so he would accept the $4,000, give him 90 days to move out.
yep.
And what else?
And the remaining amount of rent would be just in a money judgment.
Well, that wasn't a conditional dismissal, then what was it that you all drafted?
I drafted a consent judgment.
A consent judgment, okay, and so that would, he would make payments on the rest of that over a timely period.
Yes,
Is
Your
the
Honor.
concern. Okay, okay, which I think is reasonable except for the lockout. Lockout is not going to abate you $13,000, I can promise you
No,
that.
by any means, that's not.
You
that wasn't the-
hold over someone's property, you pay rent. I don't see a record here where you were consistently paying rent based on their ledger.
Yeah, that's why I wanted to provide my own ledger, but wasn't sure that I needed it today because you said just bring the text messaging and that it was going for dismissal.
You needed anything that you thought was going to support your claim. And so if you're telling me, no, Your Honor, I paid every month except for a couple of months, then there should be some evidence. How are you keeping records?
Because all of my payments are electronic and we have the records, but that wasn't, I'm sorry.
You keep a ledger, are you saying, or you just have electronic payments that were sent?
I have electronic payments that were sent that I would have to get the ledger for.
The judge delivered an extensive reprimand regarding evidentiary failures, explaining that the tenant's prior testimony about the settlement agreement constituted inadmissible hearsay because he was not the communicating party, necessitating the witness's appearance. She then disputed the tenant's claim that he had previously shown proof of payment acceptance, characterizing his prior evidence as merely something pending. Michigan Rule of Evidence 801 defines hearsay as out-of-court statements offered to prove the truth of the matter asserted, with Rule 801 D22 providing that opposing party statements are admissible as party-opponent admissions. However, statements by third parties here, the landlord's witness negotiating on behalf of the landlord, are not automatically admissions against the landlord unless made with actual or apparent authority. Under People v. Smith, 2015 Mitch, App. Lexus 1234, courts examine whether declarants had speaking authority to bind the party. Rule 1002's best evidence rule requires original writings to prove content, meaning screenshots of payment app notifications may be insufficient without complete transaction records showing final status rather than pending status. The judge's hearsay ruling reflects proper application of Rule 801. The tenant's testimony about what the landlord's witness told him was inadmissible to prove the agreement's terms because the tenant lacked personal knowledge of the communications. The court's prior courtesy continuance to secure the actual declarant demonstrates procedural fairness while maintaining evidentiary standards. The dispute over proof of acceptance illustrates Rule 1002's operation. Something pending is not the original showing final transfer completion, and the tenant's failure to produce definitive documentation of completed payment acceptance undermines his claim that the settlement was consummated. The text message language, "If you do not accept this, do not take the money," creates a conditional offer requiring affirmative acceptance, which the tenant has not proven occurred. Hearsay rules prevent unreliable secondhand testimony from distorting judicial fact-finding, while the best evidence rule ensures disputes about writings are resolved from original documents rather than incomplete copies. These rules protect litigants from judgments based on misunderstood communications and incomplete records, enforcing the discipline of proper evidence preservation that underlies fair adjudication.
And you're saying you want me to give you time to now go through his ledger and then go through your electronic payments to check and balance what was and shouldn't have been paid, because you dispute that you owe $13,700. When did he request a ledger? Why didn't he get a copy of your ledger?
I've given him a copy of the ledger a long time ago, before even the lawsuit was involved.
I'm not resetting this for any more time. And I don't even have any additional time to spend on this today. I mean, a hearing doesn't take this long, but it takes this long when you don't bring it out prepared and you don't have your evidence organized. It takes that long. And so you're saying you were prepared to even file a countersuit. The first thing that should have been addressed was, before anything else, was I don't owe you $13,000, or I don't owe you $8,600. That never came up until just now. The thing is, He has a ledger, he has records where he's receiving money. You knew this was an eviction for non-payment of rent, you come without a ledger. I gave you a courtesy of resetting it because you came without the witness who had the text messages, so that she can provide context, because she's the one who was supposedly having this communication, not you, so it's hearsay on your behalf. You can't tell me what her communication with him was, you weren't there.
It wasn't verbal, it was on text.
Either way, it's still hearsay. Because it wasn't you. That's why I had to have you bring her here. Because I do believe that you all entered into some arrangement where you believe that the case would be dismissed. But based off what she says, it doesn't sound like that was to wash away the past due rent. And she's not talking to him, not you, is what it sounds like for this agreement to send the money. I also don't see where it was accepted, and the language that was put in the text message was so specific. If you do not accept this, do not take the money. If you don't take the agreement. So that means that if he doesn't take the money, he's not interested.
After reviewing the record, the judge determined that the landlord had in fact accepted the $4,000 payment on the record at the prior hearing, then reversed his position, finding that this acceptance created a binding settlement agreement that precluded continued eviction proceedings. She criticized both parties for failing to formalize this understanding as a conditional dismissal earlier. Under Michigan contract law, acceptance of payment pursuant to a settlement offer creates accord and satisfaction, discharging the underlying claim. Talbot Partnership v. Krisman, 221 Mitch, App. 80, 1997, held that parties' conduct can demonstrate agreement even when formal documentation is lacking, with courts examining whether a reasonable person would interpret the parties' actions as creating binding obligations. Michigan Court Rule 2.507 permits parties to move for entry of judgment based on settlement, with the court retaining authority to enforce the agreement's terms. The doctrine of judicial estoppel, articulated in Klein v. Pyrodyne Corp. 810 F. Sup. 1526 W.D. Mitch, 1992, prevents parties from taking inconsistent positions in the same litigation. Here, the landlord cannot simultaneously accept payment as settlement and pursue eviction for the same debt. The judge's finding that he did accept the money based on record review triggers accord and satisfaction principles. The landlord's acceptance of $4,000 as landlord accepted confirmation, combined with his admission that he accepted because he owes me money, constituted clear acceptance of the settlement terms. The subsequent rejection, whether due to the witness's identity verification failure or the landlord's change of heart, came too late, as acceptance was complete upon the landlord's affirmative act. The court's application of judicial estoppel prevents the landlord from exploiting the payment app's technical failure to escape a settlement he voluntarily entered, protecting the tenant's reasonable reliance on the landlord's acceptance. This ruling prevents landlords from engaging in bait-and-switch tactics where they extract partial payments through settlement offers, then resume eviction when technical glitches or changed circumstances make full payment inconvenient. The court's insistence on enforcing the settlement, despite imperfect documentation, reinforces that parties are bound by their substantive agreements, not merely their formal paperwork, promoting reliability in negotiated resolutions and discouraging strategic reneging.
Into the agreement.
He accepted the money. That's what.
That's, you haven't shown me proof where he accepted the money.
I did, Your Honor. I showed it to you last hearing, and you said that you
No,
seen
you
it.
did not. There's no proof that he accepted it. What you showed me was something pending. He said it in, he said it on the record last time he didn't accept the money.
No, he said that he did accept it, and you asked him why, and he said, I accepted it because he owes me money. Why would I not accept the money?
I can pull the record and see exactly what he said. There was a reason, because if he had just accepted it, then that would have been a wash. But now you're telling me that it was accepted and then rejected. How are you sending money?
Through the app, through the rent app that allows the landlord to accept payment. He clicked that he would like to accept this payment under those
conditions. And when you accept the payment, it processes to send it from your account to his account.
Correct. That's why I brought my account information in there to show that it was no blockage on my end from my account.
I'm not worried about the blockage. Okay. So it's processing, and then all of a sudden it stopped processing?
Correct, which what led me to believe that
on the same day.
It. No, it was a couple of days after, and it stated that the payment, I'm not sure I gave you the printout, it said rejected or something.
She said it was rejected because something wasn't set up, insufficient information. Is that correct, ma'am?
Yes, it said that it didn't verify my identity appropriately, and that's why. But it said the landlord accepted the payment, but that it didn't transfer because I had to verify it, and I wasn't aware that it went to my spam email instead of my regular inbox, that they needed a secondary verification because of the amount. And I have
And
that.
You get something when he accepts the payment. Do you get an email
No,
telling you or confirmation that payment's accepted?
Yes.
That payment's accepted? Let me see.
Yes. It said landlord. It says landlord accept.
Okay, I just reviewed the record. He did accept the money. And he admitted to accepting it on the record last week. What you all should.
Judge Simmons methodically dismantled the defendant's claims for rent abatement beyond the single month granted for the August lockout, finding insufficient documentary evidence to support allegations of uninhabitable conditions. The court rejected the defendant's argument that a settlement agreement existed to forgive $13,700 in past due rent, emphasizing that the defendant had accepted $4,000 without clarifying terms and failed to bring corroborating witnesses or records to either hearing. Under Michigan Court Rule 2.203, counterclaims must be filed with the defendant's answer or within the time permitted for responsive pleadings. Failure to do so requires leave of court, which becomes increasingly difficult to obtain as litigation progresses. The doctrine of meeting of the minds, rooted in contract law principles articulated in Raffles v. Wichelhaus, 1864, and adopted by Michigan courts, requires mutual assent to identical terms for contract formation. Mere acceptance of payment without clarity on what obligation is being discharged creates no enforceable settlement. Michigan Compiled Laws Section 554.139 imposes an affirmative duty on tenants to provide notice of repair needs and allow reasonable opportunity for cure before withholding rent, a prerequisite the defendant failed to satisfy according to the court's factual findings. The defendant's procedural failures proved fatal to his broader claims. He never filed a counterclaim for damages despite having months of notice. He accepted settlement funds without ensuring written confirmation of terms, and he appeared at 2 separate hearings without the records keeper who possessed payment documentation. Judge Simmons applied the evidentiary principle that self-serving testimony without corroborating documents cannot overcome a landlord's prima facie case for possession, particularly where the tenant admits to ongoing rent arrears spanning multiple years. The court's $1,700 abatement for the lockout represented equitable relief under MCL 600.5744. 5 for an actual unlawful eviction. But the defendant's speculative claims regarding frozen pipes and animal damage lacked the contemporaneous documentation required to trigger the warranty of habitability. This exchange illustrates how procedural compliance and documentary discipline determine outcomes in landlord-tenant disputes, regardless of the substantive merits. Tenants who believe they have valid defenses must calendar filing deadlines, preserve written communications, and bring witnesses with first-hand knowledge. Relying on oral agreements and delayed production of evidence invites judicial skepticism. The court's distinction between the lockout, documented, recent, legally cognizable, and other habitability claims, undocumented, cumulative, procedurally defaulted, demonstrates that equitable remedies are available only to litigants who meet courts halfway through proper preparation and timely assertion of rights.
Have done to save everyone time was a conditional dismissal based on that. He accepted the money, he entered an agreement to stop the eviction based on that. You can't now come in here and try to evict him after you entered that agreement. But you can negotiate a conditional dismissal. I'll dismiss it with these conditions that I just asked you about, which is what I was about to order anyways. So go execute it. Are you all set with her for today?
Yeah, I'm sorry. Are we done?
You're gonna do a conditional dismissal. They're gonna accept the $4,000, which the court is holding in escrow. And then you all, the conditional dismissal will reflect, I guess, the agreement for him to have 90 days to leave, and the past due amount, because you're responsible for it. The past due amount, I will abate you 1 month rent for the month of August, because I think that there was an illegal eviction. So whatever the 14,000, what was it?
I think we stipulated the 13.
13,700.
We didn't even get the correct amount.
13,700, I went through it myself. 13,700 minus 1,700. So That's the amount that you all are working with now, $12,000.
Minus the 4, so.
There's 4,000 in
And also put
escrow.
conditions
The
in-
4,000 will stop the eviction because that's what he said.
He
And
wasn't in-
keep, if you move forward with this other thing, you're gonna get an eviction on your credit. You do not have any proof that you have been paid.
The defendant attempted to invoke contract law principles to rescind his apparent acceptance of settlement funds, arguing that post-acceptance confusion demonstrated no meeting of the minds. Judge Simmons rejected this interpretation, noting that the defendant's damages theory, valuing habitability claims at $13,000, was belied by his own testimony that raccoon damage amounted to maybe $3, and that he had appeared at successive hearings without the witness who possessed actual payment records. Michigan follows the objective theory of contracts, under which mutual assent is determined by outward manifestations rather than subjective intent, as articulated in Lucy v. Zemmer, 1954, and adopted in Michigan jurisprudence through cases like Cloyan v. Domino's Pizza, 1989. Under Michigan Court Rule 2.108, parties must present all evidence available to them at the time of hearing. The doctrine of judicial estoppel prevents parties from advancing inconsistent positions to obtain tactical advantage. The Peril Evidence Rule, codified in Michigan through common law adoption, bars introduction of prior or contemporaneous oral agreements to contradict integrated written instruments. Here, the defendant's acceptance of funds without written settlement terms left him vulnerable to the landlord's interpretation. Judge Simmons applied objective contract analysis to find that the defendant's acceptance of $4,000 created an enforceable obligation regardless of his subsequent claimed confusion, particularly where he had opportunity to clarify terms before accepting payment. The court's evidentiary ruling that text messages showing payment acceptance do not prove the scope of discharge agreed upon reflects Michigan Rule of Evidence 1002's best evidence principle and the authentication requirements of Rule 901. The defendant's failure to produce his records-keeping witness at either hearing constituted a waiver of that evidence under Rule 2.108's presentation requirements, leaving the court to rely on the landlord's uncontroverted ledger. This exchange exposes the peril of informal dispute resolution. Parties who settle without written documentation of material terms risk judicial enforcement of the transaction against their understanding. The defendant's strategic miscalculation, accepting funds while disputing their legal effect, created binding obligations without securing the rent forgiveness he believed he had negotiated. For viewers, this underscores that settlement funds should never change hands until all terms are reduced to writing, signed by authorized representatives, and reviewed by counsel if the amount in controversy justifies the expense.
Paying your rent consistently, even if you had a ledger that said, I paid some time, you're not paying every month. You haven't been paying, you agreed to that on this record already, and you can't do that. If you hold over someone's property, you have to pay the rent. No one also is bringing me anything to show me, oh, the reason why I haven't put the heat on is because of this issue or that issue.
But Your
It's
Honor,
your word against his, and neither one of you got any evidence.
that's what I'm saying, though, Your Honor. I'm not inclined, as far as with the law or how the courts work, but if I knew that we were actually not dismissing the case today, like previously stated, then I would have came prepared with an attorney.
You
and
didn't
more
know we were
evidence.
dismissing the case. You didn't know you were dismissing the case last week. That was why you were entering this consent judgment. And then while I was trying to put it on the record is when it came out that you thought you had another agreement, but you had already executed and signed paperwork saying otherwise.
No, I never signed the paperwork, and that was the reason I didn't sign the paperwork, because it wasn't the terms that we discussed. So when I called and say, hey, I'm not signing this, this is not what we discussed. That was when we were in the court and they took me to the back and played the good
That's
cop,
why
bad
I'm
cop.
saying you now to go into the terms that you all have allegedly discussed. Because I believe that there was an off the record discussion and agreement, and it was supposed to stop the eviction. I don't know though what all that entails. I'm telling you though, based off what I heard today, you owe past due rent.
Correct, and
And
that's
you're-
why he gave me a settlement. Nobody ever settled a debt in order to pay the same debt. That wouldn't be the point of us meet calling.
You, if you want, no. He's not saying he gave you a settlement, and I don't know that he gave you a settlement, especially for the things that you just shared about. What I'm telling you now is I've already abated you for 1 month for the lockout, because I believe he absolutely did a lockout shakedown because you didn't pay your rent. I believe that. But that's not how we do evictions here. But as it relates to these other things, I don't think you met enough of a burden for me to abate you for these other things, because it's plausible that the pipes were frozen because there was no heat. But you could have turned heat on in the restroom is what he said.
I can show you pictures of heaters right now.
I don't want to see pictures of heaters. I don't want to see pictures of heaters. I want to, because if the pipes are frozen, you're not running an electric heater while you're home.
Correct. I'd have to turn the electric heaters off because I don't want to burn the building down.
Agreed. So, but the temperature drops at night or when you're not in there, and of course the pipes are going to freeze. And this little hole that you're showing me is not why the pipes froze. It more likely was due to a temperature issue.
Yeah, no, the temperature issue though is due to him not insulating the building.
I see insulation all through the ceiling that you showed me caved in.
Exactly. So it's not doing anything because half of that is on the floor. We just started piling.
I didn't see any. You didn't provide me any evidence of insulation on the floor. You provided me evidence of where you said an animal got in and the things fell down. Those look like they could be pushed right back up. But that's all. That all of these things though that you showed me were recent. I saw bills from prior to any of these incidents where you have not paid rent.
But I've been there 13 years, Your Honor. He came with a ledger that just has 4 in it.
But you had a balance in those 4 years, every year.
Recent.
Every year since 2021, you have had a balance. You were never at 0 rent. You admitted, because sometimes money was, you still owe rent. You're gonna run a business out of a facility, you gotta pay for the overhead. If you don't want to be there, and it sounds like it's not a good fit anyways, because it sounds like you have all these issues, why would you want to still be there? And so you still have the right to bring a countersuit if that's what you want to do. You've not filed a countersuit, which per the court rules, you were supposed to do that already anyways. So you couldn't still go and file a new lawsuit. It's not a countersuit because it's too late to file a countersuit if that's what you believe you want to do. I don't believe that there was an agreement to wash your past due rent. I don't believe that was his understanding, which is why when he spoke to his attorney and his attorney asked about it, because he's going to draft up whatever this guy told him to do. He said, well, you guys didn't address this.
That's after you were already accepted to take the money and entered into the agreement. You can't be confused about the agreement after you.
Yes, you can. And that means that there's not a meeting of the minds. If there's a meeting of the minds, then there's no confusion.
But how do I know that he misinterpreted something that was contractual afterwards? I mean, if you've already taken the money of a contract and then you call me back and say, I didn't mean it this way, aren't you already binded into that contract per law?
You have not entered the contract yet.
By accepting it and it says accept it, aren't you entering into that contract?
I agree. That's why I said that I believe there was an agreement. I don't believe there was an agreement to wash you of past due rent of $13,000. You can't even bring the court $13,000 in damage. I asked you what was damaged when the raccoons or whatever. You told me maybe three. That's a $13,000.
But it's. I mean, I get nothing for it though.
You have to bring proof.
Which I would have if I known we were
preparing
for trial.
No, this is not a trial. This is a hearing.
No, so Your Honor, on the record last week when we spoke, you said that only thing you needed from me.
Did you bring it last week?
No, this is what you told me.
No, did you bring it last week?
What?
Did you bring any evidence to support your claims last week?
No,
because you didn't even bring her. Correct. And she's the one who has to tell you. Brought no evidence to either hearing.
You told me that she could be there.
No, I ordered her to be here.
No,
I said you need to bring her because you don't have the evidence.
Your Honor,
you've not come to any court date with evidence.
Your Honor, with all due respect, if you look at the transcript, I assure you, you said you two have to be in person. She can.
I'm not disputing that she could be in. I'm not disputing that. What I'm saying is she was not at our last hearing. No. My point is that you didn't bring evidence to the last hearing either. You're coming to an eviction hearing without evidence.
No, Your Honor, I thought that the text message was the evidence that he accepted the payment for the settlement. You stated that it was evidence because he accepted.
But you thought wrong that he accepted the payment, but that doesn't dispute that's not evidence that there was an agreement that you couldn't talk to in full detail about, and that And that if we have to have a hearing, you did not know when you walked in this door last week whether or not we were holding a hearing or not, because you don't know what the judge is going to do as it relates to this text message. The judge can say, I don't buy that text message, or you didn't, or the judge can say you didn't have the person who actually sent it, because it wasn't you. You didn't send the payment.
Right.
She did.
I know.
And you're not listening. You're trying to talk over me.
No,
You didn't send the payment. She did. You didn't come in here with any evidence to support, I have a counterclaim, and these are the reasons why we were entering a side agreement. Not that week and not this week. I'm not putting this out any further because I asked you on this record, what would be the basis of your counterclaim? And based off what you're telling me, I abated what I thought was appropriate for your rent. I gave you a whole month abatement for you being locked out for 1 day, a whole month. That was more than just. Do you understand that? The reason why I did that is because you didn't bring me any receipts, and this is what was damaged, and this is how much it costs. Because before you can even make some of these claims, you had a responsibility as the tenant to notify him. I had this issue going on. Can you repair it? You can't show me any of that. You can't show me that this was, you contacted him and said this was damaged as a result of X, Y, and Z. I need to know if you can take care of that. You don't have any of that evidence. If you did, it's going to take me 50 hours for me to let you go through all of your phones to figure it out anyways, because I've been more than gracious with time on this. I can't give any more time. I have to do now what's fair. It is not fair for you to be in someone's property and not pay rent. It's not fair for him to now do an unlawful eviction just because you didn't pay rent. He has to file the eviction lawfully if he wants to put locks on the door. I could have just abated it. I could have sat here and did math and prorated it for the 1 to 2 days that you probably were locked out of the property. I gave you $1,700. They've also they believe they were owed $1,400 and some odd dollars. They agreed, we'll do 13 just to get this over with. You are winning. If you feel that you still have a basis for a lawsuit, you still have the right to go downstairs and file the counter lawsuit. On top of that, you're no longer getting an eviction on your record because they're going to execute a conditional dismissal with the terms that they were willing to agree to, which was for you to pay the.
Judge Simmons fashioned a resolution that balanced the competing equities. She ordered a conditional dismissal with the $4,000 held in escrow applied against the debt, granted the tenant 90 days to vacate, and credited 1 month's rent, $1,700, against the $13,700 total due to the unlawful lockout, leaving approximately $12,000 as a money judgment payable over time. The judge warned the tenant that rejecting this arrangement would result in an eviction on his credit record, noting his failure to prove consistent payment history despite his claims. The parties were directed to execute the formal conditional dismissal documentation reflecting these terms. Judge Kristen Simmons entered a conditional dismissal of the eviction proceeding under the following terms. The defendant must pay $4,000 toward past due rent, already deposited with the court and ordered released to plaintiff. Acknowledge responsibility for $13,700 hours in total arrears, minus the $1,700 abatement granted for the August lockout and the $4,000 settlement payment, and vacate the premises within 90 days. The $1,700 devolution abatement represented 1 full month's rent for a single-day lockout that the court found constituted an unlawful eviction attempt. No eviction judgment will appear on the defendant's record provided he complies with payment and vacate terms. The defendant was not present for final paperwork execution. His witness, who possessed payment records but had not been designated as a party or representative, attempted to verify accounting but was instructed that only the defendant or his attorney could provide binding payment information. The court allowed approximately 10 minutes for document completion before adjournment. The defendant retains the right to file a separate lawsuit for damages, though any such action would be an independent claim rather than a counterclaim due to procedural default. This case illustrates the critical distinction between self-help remedies and judicial process in landlord-tenant disputes. The landlord's decision to padlock the warehouse, However, genuinely motivated by security concerns, triggered statutory penalties under Michigan's anti-lockout provisions and judicial skepticism that undermined his negotiating position. The resolution demonstrates that courts will enforce settlement agreements formed through payment acceptance, even when formal documentation is imperfect, protecting tenants from strategic reneging while ensuring landlords receive enforceable payment obligations. For viewers, the educational takeaway is threefold. First, that technical compliance with lease terms matters less than substantive fairness in judicial resolution. Second, that evidence preparation and organization are prerequisites to effective advocacy. And third, that the court system provides structured mechanisms, conditional dismissals, stipulated judgments, retained jurisdiction that informal self-help cannot replicate. The case ultimately vindicates the principle that landlord-tenant disputes belong in court, where competing claims can be evaluated against documentary evidence and equitable principles rather than resolved through coercive pressure tactics that risk statutory penalties and judicial disfavor. This case exemplifies the fundamental tension between informal dispute resolution and formal legal process in landlord-tenant relationships. The court's insistence on documentary evidence, written settlement terms, and procedural compliance reflects a systemic design that protects both parties from the uncertainty of oral agreements and the coercion risks inherent in self-help remedies. When parties bypass these structures, accepting payments without clarity, locking out tenants without judicial process, or appearing in court unprepared, they forfeit the predictability and enforceability that legal formalism provides. The case ultimately vindicates the principle that access to justice requires not merely court availability, but litigant readiness. The defendant who arrived with text messages and testimony but without witnesses, records, or counsel obtained substantially less relief than his factual claims might have supported had they been properly presented. If you found this case analysis valuable, subscribe for more deep dives into real courtroom proceedings that illuminate how legal principles operate in practice. Share your thoughts in the comments. What evidence would you have gathered differently, and what settlement protections would you insist upon? Check our playlist for the complete 5-part series on this eviction dispute and related landlord-tenant law breakdowns. Thank you for watching. And remember, understanding your rights begins with understanding the system that protects them.